Now, my lord, after the initiation of this case, he, my lord, was traveling from Poland to India to actually join the investigation. Now, my lord, he has been detained at the Delhi airport, and when he has informed the Delhi airport authorities that he has preferred an anticipated bail application, they are telling him either you provide us the order or we will not leave. All I would be praying for, my lord, in this application is for an interim protection so that I can go and join the investigation. For Lord, completely it's a love affair, my lord, between two young individuals. And my lord, this case is a consequence of it.
If he is detained, then how this application is maintained?
He has been detained illegally. There is no,
you cannot say that.
No arrest memo, nothing. All they
How can he be?
Yes, sir, that is what has happened. He has not been provided with anything, my lord. If I can provide them with an order, my lord, for an interim protection, the airport authorities.
No, this state will furnish a report in that.
Yes, lord. If that can be called for, lord.
Who is for the state?
Item 60.
Find out who is for the state.
Yes,
because that report will be necessary. What has happened, gone on, whether he is detained or he has been released.
Lord, can this be taken up first item tomorrow?
Find out who is for the state.
Yes, sir. That
let him come.
In the course of the day, my lord, I'll find out.
Find out and then mention.
Yes.
If I may have, my lord, kindly to mention two matters for extension of interim order.
The state filed a revisional application. The matter is, my lord, running in the list in today list as item number 157. Whereas the state has filed, my lord, the revisional application. But the problem, my lord, we are apprehending, my lord, that, my lord, there is a, my lord, the interim protection order that the returnable date is, my lord, 31st of December 2025. My lord, the next circuit will be commenced from, my lord, 15th of my lord, December. My lord, kindly, my lord, update the matter, my lord, otherwise, my lord, the state will be in difficulty. Because, my lord, there is a, my lord, order, my lord, passed by the landed trial court for pay a huge amount of compensation. My lord, the order was passed, my lord, against the state authority. So today, list, my lord, is running as item number 157. Lord, kindly update.
What is the interim order passed?
Lord, interim, the stay over, my lord, the interim order passed by the landed.
Then what is the difficulty? What is the difficulty?
My lord, the next circuit will commence from, my lord, 15, my lord.
So you filed an application for extension of the interim order?
No, my lord. We want to, my lord, dispose of the, my lord, the matter for final hearing. My lord, the learned, my lord, additional advocate general is supposed to appear, my lord, in this matter, my lord. But kindly update it, my lord.
When can be taken up?
But kindly update tomorrow, my lord, to lordship, my lord.
Because
157, my lord.
the service has been affected on the other side?
Yes, my lord. My lord, there was a, my lord, direction formula exchange of affidavits that all, my lord, formalities have been done, my lord. Affidavit and thereafter reply, all formalities have been exhausted.
Okay.
So matter is ready for final hearing, my lord.
So what is how the state is suffering for that?
My lord, state is suffering, my lord. Although, my lord, in spite of that, my lord, there is a, my lord, interim order, my lord. But we want to, my lord, finally dispose of the matter, my lord.
Mention you the next circuit. There are other matters also.
My lord, there is only, my lord, 8 days of circuit. Kindly take it up tomorrow, my lord.
No. We'll go serially if it reaches 157.
157.
When you are enjoying the interim order, then what is the difficulty?
But that will, my lord, end on, my lord, 31st, my lord.
31st of?
31st of December.
So, 15 December, the circuit will be there.
My lord, after 23rd, my lord, there is no circuit, my lord.
After?
23rd of December, my lord.
Before that, you will mention before the next available circuit bench, which is to commence on 15th December.
If your lordship kindly take it up.
How can I take it up? You are enjoying the interim order, that's fine. Mention before the next circuit. Yes.
For extension of interim order, your lordship.
Lordship, may I be permitted to mention on CRR matter?
Yes. No inclusion, no inclusion. Chalo, document.
Milord, may I be permitted to mention a matter, Milord? Milord, this matter has been was listed on under the extension of interim order, right? Milord, that has been come on the last 18 September, Milord. Due to some difficulty, the appearing advocate missed that matter, Milord, and the order has been passed for the next circuit, Milord. The prevention of the arrest was extended till 10th November, Milord. That has been expired, Milord. There is a very urgency, Milord.
What is the application has been filed?
Yes, Milord, the application has been filed, but it means that, Milord, kindly be let it be heard on the next day, my lord.
Which
Tomorrow, my lord. Possible.
application has been served?
Yes, my lord.
When did you file the application?
Pardon?
When did you file the application?
My lord, on my lord, prior to this again, my lord, we have sir filed this. On my lord, 31st October 2025.
31st October.
Yes, ma'am.
Then how the application has been dismissed or?
No, my lord, not dismissed, my lord. My lord, that has came on the 18th November, my lord. We missed it on that particular day, my lord.
10th November it has expired.
Yes, my lord.
That
That's
is released for. Yes. Oh, Mr. Guo, on the prayer of learned advocate for the petitioner list this matter before the next available circuit bench. Next.
Item two. Okay, 69 here.
What is this segment? 4036 is?
And petitioner that process of tender submitted some document.
Oh.
Amounting for false document. And thereafter you can cover the other.
Report. Learned advocate for the petitioner. What?
In month of May. After 120.
Month of May.
But month of May, 2025, it was registered, madam. On the date of July, date, they sent 2025 who appear before people. I appear on the date, on date, this, but on the specific date, I appear before this investigating officer. Thereafter, I file declare for administrative jail before this honorable high court. Therefore, honorable high court director, whatever you have the document, even interim protection, you are going to the report the investigating officer and what the investigator, I given all the first document, all these things, madam. And another thing is that, madam, due to after investigation of the complaint, madam, tender was cancelled, no loss or no pain, because there is no suffering of loss in the government agency, madam. Any government agency. I also block this statement. About this, I also block. I cannot participate any tender under my conduct, madam. One thing is that I submitted first document. This is thing. Another thing, madam. Initially, I joined the investigation. Thereafter, you was court directed. I joined the investigation. Whatever the document I given, and I also confess this was seized, madam. And part of investigation already, madam, as per my little understanding, investigation, madam, whatever may be the documentary investigation, point, madam. And I want to any stringent condition, I want to be the investigating officer and court, madam, I will face the trial, madam. This is my humble submission, madam.
Learned advocate for the petitioner submits that the petitioner all along cooperated with investigation and as per the order of this court has also submitted the requisite documents before the investigating agency. He seeks for stop. The petitioner has already been blacklisted for the reasons of furnishing forged and fabricated documents. He seeks for grant of anticipatory bail in favor of the petitioner. Learned advocate for the state opposing such prior parenthesis, if the bill submits that the petitioner has forged the signatures of block development officer Suti 2 development block. Case diary.
My lord.
Showing that one work order for construction of 4 units of additional classroom at Shahjadpur Umarpur High School and work completion certificate issued by block development officer Suti 2 development block was furnished by the petitioner. He seeks for dismissal of the application. Here is the case diary and the materials on record. And he files report of the inspector in charge dated 26 November 2025, which is taken on record. Here is the case diary and the materials on record. It appears from the records that this petitioner has furnished documents during tender process which were namely work order, work completion certificate and work order for construction of 4 units, which were subsequently found to be forged ones. Considering such materials and bearing in mind the conduct of the petition, are not inclined to grant anticipated referral. আচ্ছা আজ থেকে আমি বলে দিয়েছি সবাইকে আপনারা তিনজনই ভালো করে নাম্বার ডেট অফ অফার্স কেন টু বি মেনশন নেওয়া যাবে না, ঠিক আছে? একটু দেখে নেবেন আর ওকে বলে দেবেন ঠিক করে পড়তে। Next, 3.
Item number 3, I beg to appear on behalf of the petitioner.
Lords, I beg to appear on the behalf of the de facto
Affidavit
complainant.
of service first.
Service report.
Lordship, this.
Who is for the state?
I am for the state, Lordship.
Where is the service report?
The de facto is there, Lordship.
Did you send the notice as per order of this court? It was not sent.
Not sent, Lordship.
My lords, we have received this notice.
Yes, Lordship, we
Yes.
have received it. Yes, yes.
Yes. What is the case?
Lordship, fine. Lordship, this is a matter in the, thank you. The allegations are of section 69, 318(2) and 318(4) and 351(2). Lordship, the entire matter, this dispute arises emanates from a civil dispute. Lordship, actually what has happened, if your Lordship kindly also perishes the FIR, which is there in annexure number A. Lordship, the petitioner had borrowed a sum of rupees 4 lakh from the respondent number 2. Now, because now out of that, Lordship, some disputes cropped up between them, and thereafter, in order to implicate the petitioner, these sections were given. Lordship, if I may, in the FIR itself, it is also mentioned that out of the 4 lakh rupees, 1 lakh has already been paid. Thereafter, Lordship kindly comes to annexure number C. There in annexure number C, after the lodging of the FIR, the petitioner has already repaid back the rest of the amount. It is also there in annexure number C from pages annexure C to annexure number 17, Lordship.
No. What
The
is
bank statements are there, it is repaid back, Lordship.
why 69 then?
Lordship, 69, there is allegation that there was false, the petitioner has established a sexual intercourse on the false promise of marriage. Now, Lordship, this is the part which I am refuting, Lordship, that there was no such thing, it has been alleged in the FIR that the petitioner has kept it concealed from the victim, from the respondent number 2, that he was already married. However, Lordship, it is my submission, and I have also stated it in my petition, that the petitioner was well aware of my marriage, and some advances were made on her behalf. However, it was refused by me. It was refused by this petitioner. Now, Lordship, with respect to section 69, I have certain judgments which I would like to rely on if your Lordship kindly permits. One is Lordship from the Supreme Court, Prithvirajan versus State. That is criminal appeal number. Sorry, SLP criminal number 12663 of 2022. The other one is Lordship, based upon Prithvirajan, another judgment made given by the Supreme Court, Kunal Chatterjee versus State of West Bengal. Lordship, I am handing over the copy of the judgments. Now, in these cases, Lordship, the first one, Prithvirajan, what has happened? In Prithvirajan, similar allegation was there. However, the section out there was 376, and it was alleged that there was false promise, sexual intercourse, consent was obtained. Consent was obtained upon the false pretext, false promise of marriage. Out there, Lordship, the Supreme Court has held that the Supreme Court, after an effective hearing, the Supreme Court was pleased to quash the proceedings. It was the Supreme Court has held in page number that due to intervening circumstances, the relationship could not materialize, and hence this section was invoked, that is 376. Thereafter, relying upon that, in Kunal Chatterjee versus the State of West Bengal, the Supreme Court again, in this case, Kunal Chatterjee, the allegation was section 376, section 6 POXO, and there were other sections. In this case, Lordship, it was alleged that the petitioner was in relationship with the de facto complainant, who was at the time of minor, and there were 3 years of relationship. However, after the minor had attained majority, the petitioner had refused to marry her. Now, the previously it was alleged that there was promise to marry. However, thereafter, there was due to intervening circumstances. Again, there was a breakdown of the relationship, and that prompted this de facto complaint to lodge in FIR under 36 and section 6. In both these cases, Lordship, the Supreme Court was pleased to quash the proceeding and review of the petition. Similar set of allegations, similar nature, Lordship. However, in this case, it was section 69, and in that case, it was section 376.
Sure.
There's a copy of the resolutions. Okay.
Yes.
But one more point, one final submission, if I may. The petitioner, the victim girl in this case, has refused the medical search. Forgot to point out.
Yes.
I have already shown the 164. You mostly want to say
Nothing to say, my lords. We have nothing to say, my lords.
I cannot hear you.
We have nothing to submit, my lords.
Nothing to. Ashok, let us advocate for the petitioner submits that the the physical relationship between the complainant and the petitioner has taken place on consent. Both the petitioner and the complainant are major persons. There are allegations that the complainant has provided a sum of rupees 4 lakhs to the petitioner. However, the petitioner has refunded an amount of rupees 1 lakh.
No, the entire amount was repaid back. 1 lakh was repaid back before prior to the lodgement of
Has
the FIR.
repaid the entire amount. Promise to, entering into না, এটা এরকম ভাবে করি। Promise to marry and subsequent physical relationship between the two parties with consent would not amount to rape. To buttress his contention, he relies on the decision of Honorable Supreme Court. এই দুটো নিয়ে। This. Further, the victim has refused to undergo medical exams.
Yes.
Refused to undergo medical examination. এটাকে না আগে দিয়ে দেবেন। Victim has refused to undergo medical exam, তারপর promise to marry. He seeks for anticipatory bail, grant of anticipatory bail in favor of the petitioner. Opposing such prayer for anticipatory bail, and an advocate for the state submits that the victim, on the pretext of marriage, victim complainant has been forced into physical relationship. He seeks for dismissal. Learned advocate for the de facto complaint leaves the matter to the discretion of jurisdiction, materials, and recall. The victim in a statement, the victim is aged about 28 years. The victim in a statement has stated that she developed love relationship with the petitioner. Subsequently, she came to learn that the petitioner is married. Considering the victim has refused to undergo medical examination. Considering the aforesaid, and also bearing in mind the proposition as laid down by the Honorable Supreme Court in Prithvirajan
versus the
and Kunal Chatterjee Supra, I am inclined to extend the benefit of anticipatory bail to the petitioner. Allowed. Meet the investigating officer once in a fortnight, shall join investigation and cooperate with the investigating officer. No, service report filed by the state is taken under affidavit of service. So, দুটো উপরে দিয়ে দিন। This
ওইটা অরিজিনাল আছে অরিজিনাল না ওটা ফেরত দিই
next.
এটা অরিজিনাল আছে
Item 4. The last petition, adjournment was taken from the ground of both of the relative of the conducting officer. You are scheduled to come today, but there are miscommunication in the details of the miscommunication in the request. He would not have able to.
The advocate for the petitioner, Ms. So and an advocate informs the court that the due to death of near relative of the conducting advocate, Miss or Mrs. Miss Konok Mishro. Who is the conducting advocate? Who will conduct the case? Mr. Manoj Saha, the informs the court.
That gives you the date of near relative of the conducting applicant, which time you are signed.
She seeks for placing the matter before the next available circuit. In view of the is this matter before the next available circuit. Next.
Item 5.
taken on recall.
In total, 12 accused person, if I name accused person is there. But I have obtained a server copy of the bail order. So that kindly will pay. But whoever, 4% accused person have been granted bail.
Mohammed okay. Gone. This was
Yes.
April
But,
25,
kindly,
May
but
24.
kindly come to page 8 of the FIR.
So how many times this Muhammad Hafiz Ali will seek for anticipatory bail? This was rejected.
Lord, the Hafiz Ali, not it's a Monu Sheikh. But the petitioner before your lordship is Monu Sheikh.
Who is Muhammad Hafiz Ali?
Muhammad Hafiz Ali, alias Muhammad Hafiz. Lord, serial number
If
4.
he- Huh?
FNM serial number 4.
Muhammad Hafiz Ali Mondol.
Yes, my lord. Muhammad Hafiz Ali Mondol, my lord. Kindly come to page 9, my lord. Of my
Is there two Muhammad Hafiz Ali?
No, my lord.
Then
Hafiz Ali is one, my lord.
Then Muhammad Hafiz Ali Mondol, 21st May 2024, prayer for anticipatory bail rejected.
Rejected, my lord. My lord, thereafter, my lord, he surrendered, my lord, it's a bail order. They have
It is not an anticipatory.
bail order.
a bail order. I have mentioned the bail. They
Oh.
have surrendered before the learned trial court, my lord, and thereafter they granted bail.
483.
All of them surrendered? No.
The petitioner here,
But this order pertains to, my lord, 4 FIR name accused person.
But all of them excepting Hafiz Ali, the
Yes.
rest did not approach this court for anticipatory bail.
No, ma'am.
Okay.
But I am not with that person, my lord. Here, my lord, the petitioner is only Monu.
Hmm.
Yes.
What is the material, Mr.
But
Garba?
first of all, my lord, the case is, my lord, of 2024. Investigation has already been completed and, my lord, charge sheet has been filed. My lord, page 8 is the FIR.
এটা কোথায় কোথায় আছে এটা? If I know. Lordship, since the written complaint
Hmm.
in the year 2023, 23/11/2023,
My lord, your lordship got, my lord, page 8, my lord, FIR. Or your lordship can produce from the case diagrams. My lord, the status is that, my lord, in total 12 FIR name accused persons. So far, my lord, I have been instructed, my lord, 7 except this particular petitioner, all have been enlarged on bail. All. My lord, so far, my lord, the FIR is concerned, my lord. My lord, if your lordship kindly peruse it.
None of the accused have been extended the benefit of anticipatory.
anticipatory.
No,
Yes,
no,
Lordship.
no. My lord,
How do you?
my lord, kindly come to page 8, ma'am. That is the FIR, my lord.
Yes.
My lord, if your lordship kindly peruse, my lord, the narratives of the FIR, my lord. My lord, there is not a single line, my lord, against this particular petition. Page 8, my lord.
Person is gone.
His FIR named accused number?
Lordship, he is
The FIR name accused person number 6.
6.
6, my lord. my lord, not a single ingredient, not a single allegation, particularly, my lord, against this particular petition. Number one. My lord, number two, my lord, if your lordship kindly peruse, my lord, the 164 statement, my lord, there is also no allegation against this particular petition. Nothing.
207 complete.
My lord, charge sheet has been filed, my lord. So far, I have been instructed, my lord, by the, my lord, the learned trial court lawyer, my lord, that he has got the copies. And from him, my lord, my lord, obtained the information. My lord, kindly peruse, my lord.
Yes.
Lordship, from the FIR, if Lordship says line number 3, আসামিগণ মাঝে মধ্যে আমাদের অকথ্য ভাষায় গালিগালাজ ভীতি প্রদর্শন করে. So the name of the আসামিগণ, his name is there. So ingredients are there.
Out of a pick and choose policy, 12% have been entangled. My lord, I have, my lord, make my submission before your lordship, my lord, that there is no specific allegation against this particular petitioner. All have been entangled, my lord, joint. There must have been, my lord, some, my lord, specific allegation materials against this petitioner.
No, that's why I told you that none of the accused have been granted the benefit of.
The co-accused has been rejected, Lordship.
They have been rejected, but they have surrendered and obtained, my lord. My lord, kindly, my lord, consider, my lord, what materials is, my lord, placed before this
Yes.
particular petition. My lord, kindly consider.
Lordship, basing upon same material, the co-accused 438 bail was rejected by this court. So he surrendered and subsequently,
Yeah.
so he stands in the same footing. Number two, in the year 2023, that is 23/11/2023, another FIR has been lodged against this accused person under 307. It is in the FIR. So previous antecedent is there. Now, Lordship, kindly see page 43. He is the brother of one of the co-accused. Page 43.
This brother of the deceased.
Brother of one of the co-accused. In his land, the disease is to work. So I apologize, my junior marked the name with pencil.
The name of the deceased is Abul Kalam.
Kalam? No, this is Abul Kalam.
Yes.
So his
PM
name
report.
is there.
PM report.
PM report, Lordship, kindly says 50.
Hanging homicidal manner. He was
No, sir.
hanged. He was hanged.
He was hanged.
So far, my lord, the narratives of the FIR is concerned.
He was hanged to the tree.
There is no.
Learned advocate for the petitioner submits that there are
Antemortem
such
hanging,
specific-
homicidal.
no such allegations
suicidal.
against the petitioner, specific allegations against the petitioner, either in the written complaint or the statements of the witnesses recorded under section
Homicidal.
164 of the CRP. Out of the 12 accused persons, 11 have already been granted bail. Upon completion of investigation, charge sheet has been submitted. He seeks for grant of anticipatory bail in favor of the petitioner. The learned advocate for the state opposing such prayer for anticipatory bail submits that the co-accused persons also approach this court for grant of anticipatory bail, which has been turned down. There are allegations against this petitioner of his involvement in the alleged offence of murder. He seeks for dismissal of the application or grant of anticipated bail to the petitioner. Peruse the case diary and materials on record. The statement of the witnesses shows the involvement of the petitioner in the alleged offence of murder of the deceased. The PM report shows that the death was due to effects of asphyxia as a result of antemortem hanging, homicidal in manner. Considering such materials rejected.
Highly consider, my lord, that any person, my lord, cannot be, my lord, forced a person to be hanging, my lord.
Whatever surrender before the court. Next.
I can see 6 and 7 actually.
But my replies on
Six is
6 is Milord Chandra Prakash
Yes.
and his son Chetan. 7 Milord Saritas. Milord, few questions were raised by the complainant on the last day, Milord. I seek to reply on those points. Firstly is on the part, the prohibition under the Bengal Moneylenders Act. He says, Milord, that we are in the business of money lending. Firstly, Milord, the prohibition under the Bengal Moneylenders Act is on lending, not on borrowing. But apparently, he is the person lending the money to us, and the prohibition is on him, not us. Secondly, Milord, the moment Milord he receives that interest and pays TDS on it, we pay TDS on it, and he files his income tax return on it. He admits to the fact that he receives that particular interest. That act, Milord, of his is prohibited under the Bengal Moneylenders Act. However, Milord, the prohibition of Bengal Moneylenders Act is also not, Milord, a complete prohibition. Because two sections of that particular act are important. Milord, section 8.
7 to Dindu? 7. I've gone through Bhubaneswar yesterday.
Yes.
There is a term which has been used that until and unless the applicant authorizes. As per the affidavits filed, the term authorized was there. It has been penned through and allowed has been added. To withdraw this, file in proper form. If it is authorized, right, it is duly authorized by the petitioner to file this application.
Lord, if I may, in yesterday's matter, there's
Yesterday's matter, I was going through that
yes.
judgment and I found that in the penultimate paragraph which you indicated as paragraph 23,
Yes.
it gives a condition that it should be by the authorized agent, duly authorized. So in your affidavit herein, the word authorized, I don't know why it has been penned through, and allowed word has been added.
Mills, on that, may I,
Unless
Mills?
authorized.
Lord, that is the department's prerogative, my lord.
No, it's not department's prerogative.
Yes, Lord.
The judgment says that duly authorized. You should have, ought to have added this word that the petitioner, that the applicant who is swearing the affidavit has been duly authorized by the petitioner to swear such affidavit and file it before the court. Because the court has indicated no middleman,
Yes.
no tadbirkar.
Yes.
It will be a duly, either the applicant or duly authorized person. So in that event, I would suppose that this is not in form who has advised for cutting to pen through the word authorized and
The department. I say this with utmost responsibility, my lord. This was authorized. It was this honorable court's department which had, my lord, made this correction. We are no one to, my lord, do this on our own volition. Unless the department, my lord, directs us to do
because
this.
I was also going through the affidavits of the yesterday's matter, and there they have said that duly authorized. So I have indicated in the order that this is duly authorized.
Milord, may pass a reasoned order, Milord. I'll communicate this to the department, Milord. I'll make the necessary corrections.
Withdraw this application, file a duly of them. So then the order. If
Milord,
not,
this is a curable defect as per the appellate side rules as well. This is a
so how you
curable-
will cure this?
Well, we'll file a supplementary affidavit.
Supplementary affidavit, how this affidavit?
To Milord, only
May I,
only to this extent, Milord, we'll file a supplementary affidavit.
Milord,
That
may
can
I,
be done. As per the appellate side rules as well, Milord, affirmations, if they are incorrect, Milord, they can be cured through a supplementary.
কি ফাইলিং এ কি আছে কেন? Why did you do it?
Lord, apparently, it has seen that authorized word was typed and subsequently it was cut.
Authorized was correct.
Yes.
না না, যদি কালকে এটা করতে পারে তাহলে কালকেই করে দেবো।
Milord, may I, Milord, just submit on this point?
Who is the filing advocate?
Milord, Mr. Jagadish Chandra Rai is one of my juniors.
Milord,
Yes,
may
sir.
Yes, Milord. Milord, I have also, Milord, looked
Ask him.
further, Milord.
Mute হয়ে গেছে।
Milord, your lordship is, can you hear me? Can your lordship hear me?
Yes. Now
Yes.
you have
Milord,
raised the issue on the last occasion that since it has not been filed by the applicant, the application is not maintainable.
please, Milord.
So a division bench's order of this court
Yes, Milord.
passed an order in the year 1998 wherein it says that the applicant or his authorized agent can file an application under 438. The affidavit should be affirmed by the applicant or the authorized agent. Now the
Milord,
issue, just a minute.
sorry,
Issue
Milord.
is that the affidavit has been affirmed by a person who says that he has been allowed to affirm. Now the authorized word has been penned through. So I grant liberty to the petitioner to correct that and file a supplementary affidavit to that effect that they have been duly authorized to file this application. Otherwise, no orders can be passed. Correct?
Yes. Milords, two submissions there, Milords, if your lordships permit me. Milords, I have gone through that division bench judgment also. Milords, my humble reading and understanding of judgment is as follows. Milords, the general principle, Milords, that comes out
The
from
general
the judgment.
principle is 23, paragraph 23. I have gone through that.
Yes.
Since Mayor Todbirkar and middleman have been excluded.
Yes.
Now
Milords,
the
but
applicant or his authorized agent can file an application.
yes,
In the
but-
penultimate paragraph in 23, it says that there were certain applications which were pending before the court, and to not to dismiss those applications, court says that leave is granted to the parties to file affidavits.
yes. Milords,
Here
if
is
I
a case where the word allowed has been used. So the import is same.
Yes.
But the word authorized should be there since it says that applicant or his authorized agent. So by tomorrow you file that.
No, Milords, may I just submit, Milords, I have another, Milords, issue for your lordship's consideration. Milords, even in cases where an authorized person is filing, Milords, the reading of judgment, Milords, my understanding is, Milords, in that case also there needs to be at least some averment in the application as to why the applicant cannot come. Milords, my colleague is carrying that judgment, Milords, may I just read two paragraphs? And Milords, the court is categorical to say that
No, after consideration, we will stick to 23.
No, Milords, I
We
bow
will
down,
stick to
Milords, on
23.
that. I bow down, Milords, on that. But, Milords, my respectful submission, Milords, is twofold for your consideration. One, Milords, your lordship has, of course, seen that the word allowed is used and not authorized. But two, Milords, the general principle is that the applicant himself or herself should file. And in case a third party or a friend or a family is filing, there should be at least some averment.
Supplementary affidavit by tomorrow?
Milord, tomorrow would be difficult, Milord, day after, because Mr. Sinha
Okay.
is in Calcutta, Milord, he'll have to travel back.
Then you go the next available circuit. The last date I cannot take it.
Milords,
I
and
think tomorrow is Wednesday. Huh?
Today is Wednesday.
Milords, there's another issue, Milords. The other issue is, Milords, there has to be a power of attorney also, Milords, authorizing the person signing it.
Milord, letter of authority is, Milord, sufficient. Anyways, lad, I'm not going into that.
It appears that the affidavit filed along with this application states that the person that the deponent has been allowed to file the application. There is no averment as to whether the deponent has been authorized to file or not. In such event, leave is granted to the deponent to file a supplementary affidavit. To that effect. Is this matter tomorrow?
No, next supplement. But Friday I would be able to file the supplement.
Is this matter before the next available circuit board?
DPD. Look, item number 60 that I had mentioned in the morning, was to do some for the state.
Lordship, I'm for the state. Lordship, in that
Yes.
matter, Lordship, he has been arrested and now the application is in process, like, Lordship.
They pass the order
Yes. If you lordship.
or you
please.
get a report?
Lordship, I've just called the IOF. He's in Delhi, Lordship. He's been sent from the transit remand to caution, Lordship.
Oh,
Already arrested.
Already arrested from the Delhi airport.
get the details and file a report tomorrow. So that
Detailed
I can
report
pass.
tomorrow. Yes.
Whether he's been detained, he says that he
He-
was just orally detained.
Yes,
Since
already
there is,
detained in the airport. Yes, I got it.
if he has been produced before the court, then the arrest is complete.
Yes.
Now he will be transit remand, he will be produced in court.
Yes.
Huh? So get that report.
The detailed
and
report.
fight. So tomorrow. 60টা কালকে 60টা নেব next.
I am appearing for the state, Milord.
Very short passover. Short passover. Because contesting advocate reason court number 2.
Senior advocate अमोलेश रॉय नाम का बोलते हैं
Next.
Item 9. Item 9, Lordship, praying for a short passover, Lordship. Mr. Obijit Chowk will be. Short passover, Lordship.
You are for the petitioner.
The charges are under section 424 and 120B. I am the accused number 3 is the and there are two accused who are the primary accused. The primary accused number 1 and 2 has approached the bank who are the complainant. The foreign consideration amount for occupying loan to purchase and property from you. After getting the consideration amount, my lord, in my bank account, my lord, I have genuinely, my lord, transferred the property to in their favor, my lord. Here, my lord, that transaction has been, my lord, completed in 2022 in the month of December, my lord. Thereafter, my lord, all of a sudden, my lord, in the last portion of 2024, in the year of 2024, my lord, they have raised with an FIR, my lord, and alleging that the from priorly, my lord, that property under the mortgage within another bank. My lord. This allegation.
What is your name?
Devi Thakur.
Baby Thakur. So you are the seller.
I was a seller.
You were the seller. The flat was mortgaged to Indian Overseas Bank. You did not inform.
Milord, I did not even notice through the Indian Overseas Bank because I have nowhere involved in this. I was nowhere aware with the fact that of servicing suit has been pending against.
Not SRPC. The flat was mortgaged to Indian Overseas Bank.
Look, I was in the impression that the EA has been completed. Whatever the due were pending, Lord, that has been completed. Lord, they did not inform me, Lord. And Lord, I want to place an Lord and judgment, Lord. Pass by the division bench of Supreme Court.
First, what are the facts of the case? The person who is selling the flat
Yes.
does not have the knowledge that the flat is mortgaged to the bank. That is your submission.
Lord, they have proper.
It is your submission.
Sorry, Lord.
The original deed, how did you procure the original deed? Because you were reselling the flat to some third party, accused number 1 and 2.
Lord, no matter, like, Lord, there is no, I was not in impression.
So show me that Indian Overseas Bank has released the mortgage. You have repaid the entire amount, the mortgage was released, and now you are reselling the flat.
There was no mortgage prior to this, Lord. There was no pending,
Hmm?
there was no pending dues, Lord. And Lord, that if I are being charged under
If there is-
Lord, I'm referring to judgment, Lord, kindly see that, Lord.
Let me understand the fact. Why are you so impatient in placing that judgment? If the amount has been paid, the first and foremost to release the mortgage. This is a general. If you have a flat, I have a flat, I pay the entire due amount. What I will get? I get the original deed back to me, because deed has been mortgaged. Now, without intimating the bank, you resell the flat. How? How do you resell the flat?
I have the problem. I have the property. That's why I.
Where are the documents?
Lord, I have not annexed that.
So come up with those documents.
This is their mere allegation, Lord.
Allegation.
Yes, Lord.
Hmm?
All of a sudden, Lord, after passing 2 years, Lord, they come out with this allegation, Lord.
So there is no mortgage with the Indian Overseas Bank.
Lord, I am not even aware with that fact. Lord, they have allegedly intimated that thing, and they have included it in this account. Lord. Lord, that if I even been lodged under an defective charges, Lord, the 406 and 420 cannot be charged arising out of a said fact in the particular case, Lord.
Borrowers,
And only one
NPN upon not
utilize,
payment
Lord, that
of
is under the
dues. Imposition of property. Subsequently received an intimation notice from. Come to page 12. 12 of your application.
Yes.
What is this?
Yes, sir, the understand.
And let's say serve notice 13.2. What is your reply to 13.2? In page 12, the penalty made paragraph says that this account of Baby Thakur has become NPA on account of non-payment of dues.
Milord, they came with this
Not
being charged, Milord, by the ICICI Home Finance, Milord.
Hmm.
And this information has been derived from their part, Milord. I am not even aware with the fact that there was an due or line regarding prior mortgage mortgage of this particular property with the overseas
Indian
bank.
Overseas Bank has served a 13.2 notice under SARFAESI upon you.
Milord, there was no notice had been served, Milord. I am not even aware with that servicing to do, Lord.
You are not aware that a loan has been procured. Did you purchase the flat out of your own funds?
In this regard.
Did you purchase?
Well, now you should aware with that I purchased.
You were not aware where from the funds came. Did you purchase out of your own funds or you took loan from some bank?
For this regard, Milord, I have to take instruction. But Milord, if I comes with the refine, Milord, the charges are Milord.
Charges
What
have
is the
been
charges?
detected, that can be
You
considered.
have
That is this is not the
suppressed the
forum
bank.
of the CRL lordships. This is a case of the considerations of bail
On
lordship.
that ground, Milord, I can be enlarged on bail, Milord.
Why? You have taken loan, suppressed that, and they have approached ICICI Bank, and their ICICI Bank come to this conclusion that
Yes,
suppressing
Lordship.
proceedings
Simple
have been
case, Your
initiated against you. Only having no knowledge will not entitle you to have anticipatory bail. Come with the documents. Find out from your client.
Milord, kindly.
Huh? What is if he has replied to the surfacing notice, whether proceedings has been initiated? If initiated, whether he has filed in a written objection? What are the proceedings of surfacing?
I'll send it. Milord, kindly teach to the next.
Yes, I know your next pair will be next circuit. This is a case for fit case for the lordships for rejection, lordship. There is no case at all.
The documents.
Tomorrow, Milord,
Yes, and thereafter, my lord, Friday, Calcutta Thursday, and Friday.
Tomorrow.
No, the next second, Milord.
Yes, I know your submission will be.
Tomorrow. Produce the document, get instruction, কালকে not today করুন,
Great.
কালকে রাখো। Next.
I think
কালো তো ছিল না দেখছি। হ্যাঁ?
Married, he was supposed to appear virtually, but today I don't think so he'll appear anymore. Allegation is of keeping firearms in his home.
কি কি?
Allegation is keeping firearms at his place, lordship. Arms Act is there.
কালকে ম্যাডাম ডাকা হয়েছিল না কেউ? নোট দেননি তো? আগে ডাকা হয়েছিল নীলেন্দ্র।
নামটা? স্বপন দাস।
নীলেন্দ্র নারায়ণ রায়। রে। None appears on behalf of the petitioner, nor any accommodation has been sought for.
Separating from principal wage concept. Means try to
Yes, that's it.
Start করো।
কি হলো? দুটোই বন্ধ করে দিয়েছে। অন্য কোটে চলছে। দেখো First of all, whenever you talk over your phone, go out of the court and communicate, not within the court premises. Huh? So if he is not joining, then I dismiss this application. Yesterday also it was passed over, he never joined. Or 2 p.m. What is this happening? If he has joined, then why he is not appearing before this court? Go out of court and ask him to join. 5 minutes.
5 minutes for a full meeting.
Same issue. Better person. Next.
Same. Yesterday he is doing all these things.
Yesterday also
Yes,
he
they
did
can
not
pass over, thereafter nobody is there.
dismiss the application.
Item 12.
After 5 minutes it will be called. 5 minutes called, done.
Not paying for not to do,
Not?
not to do. Conducting advocate, you know, any elements that come today will be appearing.
Yesterday it was not today. কালকে 25 তারিখ ছিল তোমার। You move this application. Yesterday also it was made not today. What is this application?
But in IPC matter 326 is there, 307 is there. Injury grievous and 164 statement of the victim named this petition, named these 3 petitioners categorically. The role also mentioned in the 164 statement.
Madam, what are your submissions?
Instruction from my senior.
Why didn't you take it? What was the use of making it not today, yesterday? You go through the records, make your submission. You fool.
Kindly make it a Passover.
How many accused are there?
My lord, 3 accused persons are there, my lord. All the 3 persons are in this petition. He named some nickname, my lord. Kindly see the petition. Petition?
Kandu, Kandu Roy.
Yes, madam. Kandu Roy. Dipul Roy has been written.
It is
Kandu Roy has been written, alias Sunil Roy.
and Pankaj.
Pankaj has been already in the petition number 2.
Injury report? Injury report?
Injury report, my lord, page 32.
Let the advocate for the petitioner submits that. See something? You go through the records and make your submissions. You go through this. Give up the দিন হোক দেখুন নিজে পিটিশন দেখে বলুন ভালো আছে
Charge sheet submitted.
হ্যাঁ বলে দিচ্ছি Then the advocate for the petitioner submits that there are no specific allegations against this petitioner.
Na, session. 307.
Any conditions?
The upon completion, his charge sheet has been submitted in this case. He seeks for grant of anticipatory bail in favor of the petitioners. Opposing such prayer for anticipatory bail, and an advocate for the state submits that in the incident, the victim sustained grievous injuries. There are specific allegations against these petitioners. He seeks for dismissal of the prayer for anticipatory bail. He used the case diary and the materials on record. The victim implicates these petitioners of assaulting him on the date of incident. The injury report shows that the victim sustained lacerated injury, which is grievous in nature. Consider force and the nature and gravity of the offense rejected. Grateful.
Item 13.
Line for the state.
Actually, আছে ঠিক আছে আমার নাম দিয়ে দেবো
What are the sections?
But I am for the state with Dr. Arjun Chaudhary. I'll just hand over he will move the matter. I'll just hand over the CD.
Yes.
Page 9 and 10 is the written form.
The 316 is and 336, 336, 338, and 61. Okay.
That is for such a for 67 section of course.
You are the sole accused.
There are 4 accused, mother.
Hmm.
4 accused person in the event. Callicity mala form them. It is 9 and 10. Mala present petition mala Sondip Ma. You know your loss is Sondip Ma.
Yes.
Money was transferred to the account of computers on computers. You know, clear account the account. And therefore, money was reverted back to the account from the computers to the effect of company. Second, till 9. To the tune of 16 lakhs total refund. Total 13.5 lakh was credited to the account of the computers. She is the wife of the accused Amit Sharma.
35 paid, 16 refunded.
35 lakhs was credited, given by the de facto complainant.
De facto company gave 35, 16 refunded.
Yes, ma'am. 16 refunded.
Then all these documents of Indian Oil Corporation.
16 refunded. Well, accused number 1 is the Omit Sharma, madam. He is the man, he is the wife of Pompi Das. Accused number 4, madam. This right?
Amit is the husband of Pompidas.
Yes, madam.
Yes. Then
One thing, madam, money was credited in the year, madam, last month of February 2021, madam. And madam, revert back,
22.
madam, can you see, madam, page 10, last one, madam, till 18 November 2022. Madam, FIR, madam, can you see, madam, FIR registered on, madam, complaint lodged on 22nd August 2025, madam.
Okay.
Madam, present petitioner, madam, Sandeep Mahato. Madam, no connected with this, no money was credited, no money was credited directly.
Okay.
Nothing was returned. No agreement, nothing, madam. Another thing, madam, India 2000, college, madam, 2022. Here about 3 years, India lodging this complaint, madam.
Yes.
Madam, another last, madam, last two lines, madam. Madam, another first company, madam, 400 is 420 cannot be charged together, madam. There is a lordship, madam, I do not want to give regarding charge, madam. Another thing, madam, if there is a more than 3 month delay, madam, there must be a preliminary inquiry. More than 3 months, low is the money judgment, madam, more than 3 months, the period registration of the affair, madam, on this ground, madam, any other to stay, madam.
Yes.
There is no direct involvement, madam, my role, I will
Milord,
follow.
Milord, the case in nutshell is that this petitioner, along with the other co-accused person, Milord, had allured the victim, the de facto complainant, to pay a sum of rupees 35 lakhs in order to facilitate a petrol pump, opening of a petrol pump. Now, Milord, after they received 35 lakh rupees, they provided 3 letters from the Indian Oil Corporation, Milord, which later turned out to be fake. Milord, when these documents were handed over to the police inquired, verified with the Indian Oil Corporation. Milord, they said that these letters were not issued by the Indian Oil Corporation. So, Milord, these fake letters were prepared, were handed over to the de facto complainant, Milord, in lieu of rupees 35 lakhs. So, the offense of cheating, Milord, is directly, Milord, coming in the way. First. Second, Milord, they say that 16 lakh rupees they have refunded. Yes, they have refunded 16 lakh rupees, Milord, after it was found that the letters were fake and they have cheated the de facto complainant. Milord, due to pressure, a sum of rupees 16 lakh they have refunded. But Milord, I say, even if they refund entire 35 lakh rupees, still, Milord, the offense remains. The offense of forgery remains. Milord, in this case, Milord, after this present FIR has been registered, Milord, they have not been cooperating with the investigation. Milord, repeated raids have been conducted. Milord, my case diary shows, Milord, that on 21st of September, 29th of September, Milord, even in the month of October, Milord, raids were conducted. They did not, the police could not found them, Milord, they are absconding. Milord, this person, Sandeep Mahato, Milord, he is the principal kingpin, Milord, who has mediated the entire transaction with the other co-accused person and the de facto complainant. It is true that the money has been received by Pompi Das in her bank account, but he is the person, Milord, who has mediated the entire transaction. So, Milord, his role is the most important, Milord, in the entire offense. Milord, second thing, I would say, Milord, 406 and 420, my learned friend is saying cannot go together. That is a settled law. But now, Milord, this is at the stage of investigation. Charge sheet has not been filed. We do not know, Milord, whether both these sections will be there in the charge sheet or not. So, Milord, at present, Milord, considering the gravity of the offense and the, Milord, racket operating behind the entire offense, in particularly in manufacturing fake documents, Milord, of this nature, Milord, their custodial interrogation is required. So, Milord, I say, Milord, this application may kindly be rejected, Milord, so that they may be apprehended and the racket may kindly be unearthed.
What about the delay?
Milord, delay, I would say, Milord, this complaint actually was registered on the basis of a 156.3 application before the learned trial court. First. Second, Milord, there were previous attempts also, Milord, for registering the complaint, but these petitioners, they have gone to the de facto complainant, said that we are refunding the money. Milord knows, layman, he was interested in getting his money back. So at that point in time, he did not, Milord, lodge the complaint. But later on, a court complaint was filed. And on the basis of that, Milord, this FIR was registered, Milord. So, my lord, this delay is not fatal. My lord, the transactions are documented. My lord, the CD shows there was
Page 9 of this application.
lordship.
This is a complaint to the inspector in charge, not 156 clause 3.
This complaint was later given to the police also, my lord, on the basis of the complaint given to the court. A court complaint was given. There was a direction for registering the complaint, and then, my lord, a separate copy of the complaint was further given to the police. This is my instruction from the investigating officer, my lord.
But that is my lord, first a complaint is. It is not received by the, or not entered, then 156 comes. After the 156 has been registered, my lord, the city FIR has been started, there's a fresh complaint coming.
No.
Thing is that is,
There
is already a temporary defalcation, my lord, you cannot come out from that.
Procedures, if there
This
is no registration, then 156 procedure, there will be amendment, but nothing. Can you please tell also? Can you, from the case there is show that.
Where is the copy of the 156 3?
Must be there must be order of the magistrate, my lord.
Copy, Mr. Chaudhary, copy of 156 3.
Lord, that is not there in the case diary. Lord, my investigating officer has instructed me that there was an order from the trial court relating to a report. Initially a report was called for, a report was given by the police, and thereafter an order was also passed. But after the order was passed, this complaint was registered, but this copy of the complaint was subsequently taken by the police from the de facto complaint.
There is no amendment in the complaint also. Nothing. There is 156 or must. There must be order.
Para?
Paragraph 38.
Which judgment?
Delhi Race Club Limited, 400 significant.
Delhi Race Club is on 406 and 420. My lord, that is the settled law. I am not disputing it.
Para 38.
Para.
And this judgment, Lalita Kumari?
120. Regarding the mandatory.
This is an application for quashing. 100 and?
There is a guideline.
100 and?
Guideline, order of Supreme Court.
Which paragraph?
120 of the judgment. That's 120.6. E. Cases where is abnormal delay latches initiating criminal prosecution, for example, over 3 months delay in reporting the matter without satisfactory explaining.
Commercial offenses.
First thing, where there must be preliminary inquiry conducted. It's said to the matrimonial dispute and all these things.
Which case of আসুন। Learned advocate for the petitioner submits that the allegations in the FIR is in relation to opening of a petrol pump wherein an amount of rupees 35 lakhs were alleged to be paid to the accused persons. Stop. There are also allegations of letters being issued, acceptance letters on the letterhead of Indian Oil Corporation Limited has been issued. The part of the amount that has been transferred by the complainant has been repaid to the tune of rupees 16 lakhs. 16. The allegations under section 406 and 420 cannot be sustainable jointly. In support of his contention, he relies on the decision of Honorable Supreme Court in Delhi Race Club 1940 Limited and others versus State of Uttar Pradesh and others. Furthermore, there is a considerable delay in lodgement of the FIR, unexplained delay in lodgement of the FIR. And therefore, a preliminary inquiry needs to be conducted in such circumstances. There are, to buttress his contention, he relies on the decision of Honorable Supreme Court passed in Lalita Kumari versus Government of Uttar Pradesh and others, reported in 2014, Volume 2, SCC 1. Further, the amount has been transferred to the account of one Pompa Sharma, Pompa Das, who is the wife of accused number 1, Amit Sharma. Pompi Das. There are no such money transferred to the account of this petitioner. He seeks for grant of anticipatory bail in favor of the petitioner. Learned advocate for the state, appearing through virtual mode, submits that the petitioner played an active role in alluring the complainant to part with an amount of rupees 35 lakhs on the pretext of opening a petrol pump. Acceptance letters were issued since further steps were not taken. The petitioner approached the Indian Oil Corporation and during investigation, it has come to the knowledge of the investigating agency that those letters are all fake and fabricated one. Though the proposition that 406 and 420 are not sustainable together, but the investigation is under progress and charge sheet is yet to be filed. The documents as collected, the materials as collected during investigation primarily shows that the documents have been fabricated, namely the acceptance letters issued by the Indian Oil Corporation. The delay was due to the fact that the complainant was interested to have repayment of the entire amount, and being a layman, such delay has occasioned. Be that as it may, the offenses of forging of documents are palpable on record. He seeks for dismissal of the grant of anticipatory bail. And dismissal, ये तो state तो dismissal and dismissal of the grant of anticipatory bail. Any statements have been recorded from the Indian Oil Corporation from the office of the Indian Oil Corporation
No, my lord, there is a verification report from the IOCL, page 89.
89. Here is the case diary and the materials on record. As per the verification report of the Indian Oil Corporation dated 3rd September 2025, it is found that the documents which were sought to be verified are found to be not genuine and has not been issued from the office of the Indian Oil Corporation. The allegations as revealed in the written complaint is that this petitioner along with 3 other accused persons have assured the complainant of opening of a petrol pump and an amount of rupees 35 lakhs have been transferred to the account of one Pompi Das. There is repayment of 16 lakhs admittedly. Be that as it may, the offenses, criminal offenses of such a nature cannot be washed out on the basis of a repayment being made. The investigation is under progress. It is not a case that 406 and 420 has been included in the charge sheet. Therefore, the proposition of the Honorable Supreme Court in Delhi Race Club may not apply at this point, at this stage of investigation. The direction to hold preliminary inquiry in Lalita Kumari Supra is with regard to verification of the veracity or otherwise of the information received. There cannot be any quarrel that there is a fabrication of the document which is supported by the verification report of the Indian Oil Corporation. Considering the aforesaid and the aforesaid materials and the nature and gravity of the offense rejected.
Grateful to you.
Hajiye Devene.
Item 10 and 11. 10 and 11.
Come on, now. Lordship, kindly look at the 161 of the wife, Lordship, before
One-
passing it.
164?
The husband used to bring firearms to the house and she does not have any.
Because he's the husband.
Yes,
And the other one?
the wife.
No,
The wife was arrested, Lordship. The husband is absconding.
না না দুটো তো আলাদা মনে হচ্ছে এই দুটো আলাদা আর কি অ্যাডভোকেট সেম দুটো আলাদা 10টা কত নম্বর
Item number 10, Boxirat Police Station.
বক্সিরহাট
Yes, Boxirat 287-2025. তাহলে বল নাম নিতে অন্যদের করে না করে
দেখো কি হলো কি ঢুকবে কি ঢুকবে না হ্যাঁ None appears on behalf of the petitioner. Despite opportunity being given to the petitioner to learned advocate for the petitioner to appear through virtual mode, he has not joined. Considering the above, the application being CRN A773 of 2020 is dismissed for non-prosecution. Wait for my next.
Item 11. I am for the state ruler, same defense counsel.
Similar.
I am grateful to your lordship. Item 8.
Mr. Senior Advocate Amolesh Rai, the clerk is present here requesting me, he is engaged in court number 2, short pass.
Chalo, next hello.
Item 14.
I am for the state, my lord.
Okay.
What is this allegation? It is number 3. 3 is pregnant. Assault and snatching. What is 126? 126?
126.
This is the FIR 479. Yes. Kalpana, Madhavi.
How good see that?
Bimol developed. Bimol. Raju.
Lorships, actually what happened, your lordships, the police had been to conduct the raid to arresting the culprit, and the adjacent neighbors are started beaten up, and out of that quarrel, one officer sustained injury, and all the statements, your lordships, revealed that incident, your lordships. And regarding the injury report, is lordship, I have already. 65 and 66, your lordships. CS not filed.
Trauma. Where is the injury report?
Lordships 65 and 66.
No, he was discharging his duties, or he is the neighbor, he entered into the house. What is it?
Lordships, the fact is revealed that suddenly they have started beaten up, and once some 161 statement that they had been to conduct the raid, lordships.
Simple. Narayan. Punji. Simple.
Christian, there is Catholic and one Catholic moment. Basically, the accused, basically the complainant came and
Sanjit Das, SRP.
a woman person SRP, something committed mistake, I cannot face the open court, and at the time of rescuing, one whose personal. They are the neighbor, there is the enemy, most of the all the
Police personals and the petitioners are neighbors.
no, police personnel suddenly came to stop the quarrel. And all this is the police personnel suddenly. Not that police personnel.
Oh.
He person beating on the woman beating the store. He entering the house. Committing some mistake with woman.
Out of these provisions, which is the non-bailable offence?
First, the earlier now.
Lordship, another 304 is snatching one chain, that is also recurring in the verse 61.
304 is non-bailable.
No.
353 is not there.
Now 130.
Oh.
Now.
And theft is non-bailable. 304.
379 Lordship, theft. Non-restored, non-value.
This is 304 now.
Yes, Lordship, 304. Snatching.
Snatching.
Can I advocate for the petitioner submit that the on the date of incident there was dispute between the petitioners and their adjoining neighbors. The police personnel intervened and sustained injuries. There are no direct allegations against these petitioners. He seeks for grant of anticipatory bail in favor of the petitioners. Opposing such prayer for anticipatory bail, learned advocate for the state submits that in the said incident, the police personnel sustained injuries and had to be hospitalized. He seeks for dismissal of the prayer for anticipatory bail of the petitioners. Here is the case diary and materials on record. And any of the other persons got injured? The neighbors?
No.
No.
The man did something, beating by Christian rule, one person. No, sir,
Please get materials on record. It is found from the statement of witnesses that on the date of incident there was an incident of assault.
Lordship,
The-
Visual list page 33. Sorry to interrupt, Lordship.
The police personnel
Bamboo and
who intervened, both are police personnel, Narayan Das and the other person Sanjit Das
Sanjit Das, SI Sanjit Das.
and Narayan
SI
Das.
Narayan. Narayan is a ASI, Sanjit Das is SI.
The police personnel who intervened got injured. In the incident. The nature of injury is simple. Considering the above, trying to extend the benefit of anticipatory bail to the petitioners. Allowed. देंगे not है आधा हम देंगे not और देंगे next
This is second application lordship. You will be getting to the first application lordship. Charge sheet has been submitted. Lordship, there is two applications. One is already granted anticipatory bail by the learned
that is Judge Push your lordship. Kindly produce the lordship postmortem report.
This is an application of a legal proceeding. What legal steps you have taken? What was the legal steps taken by you? While withdrawing the earlier application, you submitted before the court that you sought for liberty to take appropriate legal proceeding in accordance with law. Liberty was granted to you. Application was dismissed as withdrawn.
Accurate record. Therefore, I applied for certificate copy and have already annexed the charge sheet copy in this application website. Page 15, annexure people.
What is your name? 108. 108 is corresponding to which section?
306. 306, lordship.
How many accused are there? What is the status of other accused?
One person is granted excluded bail lordship.
Where is
Page
that?
number 13 lordship.
13.
13, must be. And it should be stubborn to them.
Yes.
Lordship, at first, kindly goes through page 9, annexure P1.
Yes.
Second paragraph, lordship. Now, I humbly submit that this petitioner is not the same footing with the female accused who was granted anticipatory bail, as because the allegation of this petitioner is not only, lordship, I'm a little old school, so I'll submit regarding IPC and JPC. Lordship knows better than me that to attract a section of 306, 107, 108 has to be established, whether the abatement is there is not. This petitioner not only abated, but also falsely represented himself to be a police officer. And by such, he put pressure upon the deceased so immensely that he took his life. The lady who has already been granted anticipatory bail had a relationship with the deceased. Subsequently, she changed side. She opted for better option. I may use this much only. And so to keep this disease away from her life, this petitioner entered.
Petitioner is the husband. He's not the
A friend, I may use the word friend of the that says Shaboni, who has been already granted anticipatory bail. Now, lordship, kindly sees. This is the case diary, lordship. Statements are there, lordship. 164, 161 statements are there. May I take your lordship to page 34 onwards? if Lordship goes through those communications, Lordship will find how this petitioner put mental pressure upon that person who was a beautiful cricketer. He was a wonderful cricketer.
Yes.
Now, Lordship, kindly sees page 85, 86. 86 is the more relevant portion. Now, page 62.
Who is this?
Lordship, the aunt, neighbor aunt. Page 22. Another 164 statement. Lastly, Lordship, 24, 25. Connection established.
Tapos is deceased.
Lordship,
Tapos is deceased.
is the deceased, Lordship. Lordship will kindly appreciate that a common person, if any person makes any correction with his, like what has been happening nowadays, that digital arrest, a person falsely saying, and even the common person having no knowledge of law in various fields, in government officials also, they give the money out of fear. So this person purporting himself to be a cybercrime officer of Assam made the connection, and that, I may use the word, the young man
Ashok.
committed suicide.
The learned advocate for the petitioner submits that there are no such specific allegations against the petitioner of abetting ABET, abetting the suicide by the deceased. Upon completion of investigation, charge sheet has already been submitted in this case. Stop. Who accused have been granted bail. He seeks for grant of anticipatory bail in favor of the petitioner. The petitioner renews his prayer for the earlier application being CRN A 521 of 2025 was dismissed as withdrawn. Opposing such prayer for anticipatory bail, learned advocate for the state submits that the co-accused Shravani Pramanik had previous love affairs with the deceased victim, which turned SAR, SOUR. Thereafter, the present petitioner impersonifying as a officer of cybercrime pressurized the victim on the pretext of entangling him in criminal cases. Which has ultimately forced the petitioner, forced the deceased to commit suicide. PM report?
Lordship, PM report, page 102.
Peruse the V6 for dismissal. Peruse the case and the materials on record. The statement of the witnesses recorded under 164 as well as the WhatsApp 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 message shows that this petitioner impersonified himself as additional inquiry officer, cyber cell, Jalpaiguri.
She's Assam.
What he has written Jalpaiguri.
Jalpaiguri is
And
this.
there is also a reflection that he will be filing complaint against the victim. The victim committed suicide thereafter. As per the PM report, the death was due to effects of hanging, effects of asphyxia as a result of hanging, which is antemortem and suicidal in nature, considering the aforesaid materials rejected. Next.
Proceeded to the signature.
I can say.
Yes.
Even.
Why?
That which will record out of station, that is medical treatment, won't be able to make it within this time.
What is his name?
Pratap Khatri, Your Lordship. Mr.
Then
Pratap Khatri.
what is your name?
I think Divash Kumar Nandi.
Mr. Vivash Kumar Nandi, learned advocate, informs the court that the conducting advocate, Mr. Pratap Hati, has left the station for his medical treatment. Stop. He seeks for placing the matter before the next available circuit bench. In view of such submissions, place this matter before the next time.
Get from my please.
I can say
After the statement.
Not register under chapter 41, 420, injury report, 27, 25, 37, 44, that is not other Lordship, it says, all the qualities by two option your I must say to your lordship, I will see the order again. I will see the list 16 and it is your lordship.
Yes.
What should be injury condition? Kindly produce the injury.
Not to kindly see the dictionary order, page 16, there are 4 your lordship.
Where are the statements?
Statement. My lord, page 10, my lord. 10, 14, 15, 16 onwards.
Ten.
10, my lord, thereafter 14 to 17.
What is your name of your client?
Yeah, it is not clear your lordship.
Ashim Kumar Borman.
Charge sheet has been filed.
Your lordship.
He is the last person. Is a reading arrest from more than 1.5 years, more than 2 years, 1.5 years.
Osim was named in the FIR.
Lordship.
Yes, charge sheet has been filed.
No, FIR, in the FIR, his name was there.
Lord, if I am Lord. Yes, yes, the last person.
12, 12. Even charge sheet, accused number also 12, number of the charge sheet.
Awesome.
Lord, he has been evading arrest from last 1.5 years, my lord.
The advocate for the petitioner submits that all the co-accused have been granted anticipatory bail by this court. All co-accused persons have been granted anticipatory bail by this court. By this scope. The present petitioner stands on the same footing. Upon completion of investigation, charge sheet has been submitted. Stop. He seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for anticipatory bail, learned advocate for the state submits that the petitioner has absconded for a considerable period, seeks for dismissal of the prayer for anticipatory bail of the petitioner. AUZ is diary in the materials and record. It is found that co-accused persons have been granted anticipatory bail in CRMA 663 of 2024 and CRMA 17 of 2025. The petitioner stands on the same footing. Stop. In view of the above, I am inclined to extend the similar benefit to the petitioner. Accordingly, further continue the investigation every day she not. And shall meet the inspector in charge of which police station?
Jalpaiguri PS, madam.
Of the concerned police station. On every fortnight until further order. Allowed. কোর্টে অ্যাটেন্ড করবে এরকম এডিওটা বলে দেবেন তো বাদ দিয়ে দেবেন নেক্সট
Item
18, my lord. 18, my lord, learned counsel, Mr. Deepankar Dev is appearing for the petitioner, your lordship. His mother has admitted to hospital today morning. I'm praying for not this week.
Next circuit say, not this week, there cannot be a submission like
What
that.
is your name, madam?
Onchita Sarkar.
শিখা সরকার
Onchita Sarkar. Onchita Sarkar, your lordship.
Yes, Miss Onchita Sarkar, learned advocate appearing to virtual mode, seeks accommodation on the ground of Mr. Deepak De. Deepak De?
Deepankar Dev, your lordship.
Deepankar De.
Deepankar De.
And
Dev.
she
Dev,
seeks
your
placing the matter before the next available circuit.
grateful, your lordship.
Yes.
Item 19.
দীপঙ্কর দেব হবে বুঝলে দে নয় দেব এখানে যা দেখছি এখানে দেব আছে Yes. 20 on the prayer learned advocate for the petitioner list this matter before the next available circuit.
19 there. 19 তোমার নাই তো সুগীতের মাঠ
You are for 19? 19? 19 to 20 the same order. Shumi Das. CD is there? Tomorrow will take.
Tomorrow.
Not today. Mark করে দেবেন, mark. Same order as 19.
I'm appealing for the statement.
Each of PLS.
306, my lord.
306 of I. When it kindly comes to page number 9, your lordship will find a FIR. Wherein it is alleged that on 13th of May 2025, the victim girl committed suicide. And the FIR was lodged on 13th of August 2025. My lord, there is no allegation against the petitioner. Just the parents found a mobile phone and my name as well as on a list. Lord, that is everything.
You are the landlord?
No, I'm not the landlord. Lord, I'm just a friend of.
Allegedly, my lord, petitioner is the petitioner and the deceased has love relationship. This is the allegation. My lord, postmortem is there, my lord, page 23, antemortem hanging. It Deven.
My instruction goes below, there is no suicide note.
Suicide note is not there.
Where is the statement?
My lord, 161 statement of mother, page 6, neighbor independent witness, page 7, 8, 9.
Mother is page 6.
Mother is page 6 and 7, 8, 9 are the neighbor and independent witnesses.
When the advocate for the petitioner submits that there are no such ingredients of any abatement to suicide against the petitioner. He seeks for grant of anticipatory bail in favor of the petitioner. When the advocate for the state opposes such prayer. It is the case diary and the materials on record. PM report?
PM report, page 23, my lord. Just a second. Page 23. Death was due to antemortem hanging.
Here is the case diary materials on record. On going through the statement of the witnesses recorded on section 160 on the CRPC, it is found that the victim had previous love affairs with the petitioner. The death of the, as per the PM report, the death of the victim was due to effects of hanging, which is antemortem in nature. There are no such specific allegations against the petitioner. Consider above, I am inclined to extend the benefit of anticipatory bail in favor of the petition. Allowed.
Or kindly impose some condition, my lord, as because the
investigating
investigation
officer
is in progress, my lord.
Made the investigating officer once in a fortnight join investigation and shall cooperate with the investigating officer attend the court on the date fixed for appearance.
Grateful, Lord. Grateful.
Next.
Lordship, I am for the state lordship in spite of petitioner, your lordship.
Yes.
Lordship, in spite of requesting several times to the investigating officer, he is not producing the original CD and the certified CD, lordship. Praying for personal appearance, lordship. Tomorrow, along with the CD, lordship. Tomorrow, lordship.
Which police station is this?
Lordship,
So take up the matter with the additional public prosecutor, Mr. Chakraborty. What is the state to do? State can be made a party. If the state machineries are not functioning as per your instruction, and you seek the order of this court to produce the case diary, how is it?
In spite of.
There is no responsibility of IO to produce the case diary. Where is Mr. Aditi Shankar Chakraborty?
He's out of station, I am there.
So why, what's he submitting that in spite of several letters being issued, the IO is not producing the case diary?
But already we have complied, my lord.
It is informed by the learned advocate for the state that despite there being letters issued to the investigating officer to produce the case diary.
Yes. But today they are saying today, as per the office information, today we'll receive the CD.
Oh, you have received it?
Today we will receive.
Make it tomorrow then.
My lord, tomorrow.
No. Who is for the petitioner?
Na,
Tomorrow.
Allegation is not section 6 of the POCSO Act. But the
Affidavit of service.
service. He has been.
27. My lord, I am on behalf of the petitioner. My lord, in this case, victim is required, my lord.
Wait,
Victim is required. My lord, it is,
What is the provisions?
My lord,
69.
Section 69.
promise to marry and
Deceitful.
deceitful means, Lordship.
Affidavit of service?
Lord, I have not made the service. I have not been
Attached the postal receipt.
मजा लिखे थे. Which police station is this?
My lord, Alipurduar Women Police.
State. Can the service be affected by tomorrow?
Kalke. My lord, which station? This was Alipurduar. Alipurduar, Lordship, day after tomorrow. Friday.
Friday दिन रखो. Act of will application. An advocate for the state seeks, petitioner seeks accommodation to file affidavit of service. Let such affidavit of service be filed on the returnable date. Please this matter filed. Yeah, please file. In the meantime, state serve.
For item 38, I'm saying for next for item 20. Kindly note that.
Right. What are the sections?
Not 14A and 14C of Foreigners Act.
Move the application. What is that?
The first time the information kindly note. As Mr. Omik will appear in this matter, but we do some personal urgency. That's just to home matter.
And the parents are trying to cross Bangladesh. Provide documents across. The prayer of learned advocate for the petition release this matter before the next available circular.
29.
नहीं, not to Dagdir.
30.
For item number 30 and 31, this is on next Sunday.
And for the state.
30 and 31.
30 and 30.
Why 30? What is
32 is.
ठीक है 30 टा देखिए
রমানন্দ কি মানুষ মেরেছিস? মানুষ মেরেছিস?
What are these sections? T29. T29 is corresponding to which provision?
কিন্তু আমিও ভুলে যাই পড়ে এগুলো না, ইটস ভেরি ডিফিকাল্ট টু রিমেম্বার। আই অলসো ফরগেট। I just read the facts and like apply the sections of the IPC, my lord.
T29.
হ্যাঁ রিভিয়াস আর্ট আছে না, রিভিয়াস আর্ট নাই।
Criminal trespass.
ক্রিমিনাল ছাগল মেরে ফেলেছে, ছাগল যে ছাগল মেরেছে তাকে আবার মাথা পাঠিয়ে দিয়েছে।
Grievous hurt, yes, 117.2, 74. That's all. Criminal 470. What the 118.2. Hurt, grievous, and dangerous weapons. 351.
এই বড় আমি মনে রাখতে পারি না এগুলো।
20 Yes. Move the application. Take this.
বিল পাবি করবো
না না
মুখ কর
সার্টিফাইড আছে না অরিজিনাল আছে
কি
সেটি
বলছে এই যে ছাগল মরা ছাগলটা
ঠিক আছে
Actually, civil of nature. If you kindly see page number 16, there is also a complaint of this burden of police interest. Over here, these complainant also, that they have also trespassed the land and also tried to.
Okay. Yes, Mr. Vishal.
My lord, fracture of the temporal bone, temporal region, my lord. 2 fracture, and this is the injury report, my lord, and 164 statement mentions him. There is every ingredient of 118.2. মাথা একদম গুঁড়ো গুঁড়ো করে দিয়েছিস মেয়ে হুম
My lord, in page number 16, of my application.
Your application, the brief is with you. Page 6. 60. পরিমল সরস্বতী দুর্গা
Both the participant access plan. That's the main. That is offered.
ছাগল তো মেরেছিস মারানি হয়েছে ঘটনা হ্যাঁ বললাম কি
Injury report?
34, my lord. I have marked it. Fracture is there. Temporal bone. Temporal region.
One injured.
Yes, my lord. Fracture is there, my lord. Quite visible. And 164 mentions his name also with the other accused persons. Huh? কি?
Statement of the injured.
The injured.
Injured,
161 statements are 8, 13, 14 and 15.
injured has named which of the assailant? Which person to be the assailant?
May I see one?
চাইছে?
না আমরা এগুলো আমি দেখি নাই তো বললো না তো অন্য কাজও প্রচুর
The advocate for the petitioner submits that the FIR has been initiated out of long-standing dispute. Previously, the petitioner also lodged complaint before the Superintendent of Police Alipurduar with the allegation of criminal trespass. He seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for anticipatory bail, the advocate for the state submits that the victim sustained grievous injuries in the said incident. He seeks for dismissal of the application for grant of anticipatory bail of the petitioner.
স্টেটমেন্টই করেনি নিমাইদা নট ইট রেকর্ড সেশন হয়নি এখনো নিমাইদা শুধু হসপিটালে ছিল রেকর্ড হয়
Hori's statement is there. Horidas.
হরিদাস উপেন দাস ইজ দেয়ার
Upen is not the injured.
হিতিশ দাস ইজ দেয়ার
Nimai and Hori.
No, my lord. Maybe they were sick. Investigation is still going on. It will be recorded. At all.
Good guy. It is accused by the materials on record. It is found that in the said incident, 3 persons sustained injury. One of the injured sustained lacerated injuries on the 35. Lacerated injury on the parietal region. Comma, temporal bone fracture. And condylar head fracture. CONDYLAR, head fracture. And the nature of injury is grievous. There are allegations against the petitioners of assaulting the injured persons. In considering the consent extent of complicity of the female accused, namely petition number 4 and 5, I'm inclined to extend the benefit of anticipated bail so far as petition number 1, 2, and 3 are concerned. The same stands rejected. Female is cooperate with investigation. Partly allowed. 1 and 3, 1 to 3 rejected, 4, 5 allowed.
Right. Excellent. 8 months, probably I know 8 months. My wife have one decision, so later on, I couldn't.
Yesterday that was regarding affirmation of the immediate.
Oh, you're lost. You're lost. After that, I will later authorize. I can't my something next time.
Let me come back after the recess. Let me go through the file, what has been stated in the.
I'm like that, because I can do that.
Who is for the state? Let me come see the file. What have you stated in the affidavit?
No, I'm also ready. Today I'm living in the.
Today you are living.
Protocol.
Okay.
Thank you.
Okay.
Yes, sir.
Sure. Oh, there is a mistake in the name of petition number 6.
Yes. Mistake, my lord.
Sir.
With the wife of Nampodar Roy and daughter of Rupida Mandal alias.
Will not press is there or?
You can get it corrected, sorry. Liberty.
ঠিক করো। What is in the FIR?
Roy.
আচ্ছা। একাদশী রয়, স্বামী গুরুপদ
Wife of Rupida.
on the prayer of learned advocate for the petitioners.
এটা আমার মনে হয় নট করে দিতে ফ্রেশ করে কনফিউশন তৈরি করে।
What will do?
পরে আয়।
Petition also innocent, my lord. I think totally civil mention.
নাম গুরুপদর একাদশী নামটাই চেঞ্জ, বরের নামও চেঞ্জ তো, হরিদাস মন্ডল করে দিয়েছি সেখানে।
That will be my daughter of.
মানে এটাকে নট প্রেস করে গো, এটা এতগুলো চেঞ্জ করা মুশকিল।
Chalo, on the prayer of learned advocate for the petitioner, liberty is granted to correct the specification in of petition number 6. She is the daughter, wife,
Yes,
female.
she is the daughter of Holidas Mandal.
Correct.
Wife of-
তাহলে ওটা 1 2 3 একে বলে দেবেন 1 2 3 rejected 3 4 6 4 5 6 allowed. Correct that.
Yes, sir.
Next. 8, yes.
Number 8. Yes.
On the prayer of learned advocate for the petitioner, learned senior advocate appearing for the petitioner, let the matter be placed before the next available circuit bench.
পড়ার ছিল আগের দিনের দাঁড়ানো আছে।
My wife,
If you want to place anything, you place before the next to get that document.
স্যার
Next circuit. Yes.
এপিপি কল হ্যাঁ হ্যাঁ
everyone, where I got a petition, all are accepted petition member, all are paid for and because they are all candidates, but no, 23 person active in the church, other village, 24 active person, 23 are granted and from page number 37 to page number 4.
What is your name and what is your serial number in the charge sheet?
My lord,
Your
no man, I'm for the state.
Bimal,
Milan Lafrangla.
Milan. Milan is serial number.
Page number 36, 6 number. Page number 36, serial number 6.
Milan.
My lord, the prosecution case is that, my lord, a dead body was found, and my lord, the police, my lord, took up the investigation, and my lord, meanwhile, my lord, a violent crowd, my lord, in the name of my lord agitation, my lord, they, my lord, vandalized the police van, my lord, they assaulted, my lord, the police personnel, and thereafter, my lord, this suo motu case has been started. My lord, all alone, my lord, the crowd was consisting of more than, my lord, 50 persons, including, my lord, this petitioner.
The others have been granted bail.
Yes.
Any other specific
Yes, this
allegation?
is the prosecution case, my lord, almost 24% has been charge sheeted, and my lord, most of them have been, my lord, granted anti-bail, my lord, by this honorable court.
The advocate for the petitioner submits that the other co-accused persons have been granted anticipatory bail by this honorable court. The petitioner stands on the same footing. He seeks for grant of similar relief in favor of the petitioner. Opposing such prayer for anticipatory bail, learned advocate for the state submits that during protest for demanding justice for the murder of one Manoj Lohar.
Yes.
Manoj Lohar. This petitioner, along with others, vandalized the police van and the police station.
No, my lord, not police station, my lord. A police van was vandalized and thereafter, my lord, the accused person's home was, my lord, put into, my lord, fire.
The house of the accused in the earlier criminal proceedings was
Yes.
put to fire. He seeks for dismissal of the application. There is a case diary and the materials on record. It is found that the other co-accused persons have been granted anticipatory bail in CRM A 951 of 2024, CRM A 990 of 2024, CRM A 452 of 2025. CRM A 490 of 2025. The petitioner stands on the same footing as of the other co-accused persons. Accordingly, I am inclined to extend the similar benefit in favor of the petitioners. Hence, I am inclined. Accordingly, same. What was the condition?
Lord, 482(2), to appear before the learned trial court on the each and every date of, my lord, the
Yes.
date fixed for trial.
Yes. In the event there is failure, the jurisdictional court is at liberty to cancel the real condition. Allowed. What are the sections? You go through the records and make your submission. What are the sections?
Sections are 109 trespass, 115(2), 117(2), 329, 351, 49 and 74 of the BNSS.
115(2) is grievous harm.
Yes. The medical is there.
Shunjit. Sobhita is the.
Yes, Sachin.
Sobhita is the injured.
Yes. Sabita is injured. Yes, Sachin. Alleged
Sabita is injured.
physical assault by 3 persons dated 1/9/24/25. Neck, state of injury, neck, head by her.
What
This
is
is
the
what
injury?
Actually, Lordship, it is neither stated simple or grievous. So this is what the report is.
Simple.
It's a simple.
Then you will move. Visible assault by 3 persons.
There are 3 alleged persons, one of them was already granted by the judicial court, named my lord. Ika Roy. Case number 15 of my petition. Annex 15. These all 3 granted.
Geeta is the wife of Sanjit.
Yes.
Mother. State of injury, great temporal region.
Gita is the mother of
Bravo. Any hospitalization of that sort? Nature of
Hospitalization.
injury, day. What is state of injury is? Site of injury.
And note to coding is all.
Well, my lord, there is no details in the proceeding. To this complaint, my lord.
Hmm.
And
There is. He was admitted to the hospital, the injured. Please.
Page number 34, my lord. Page 34.
One day. Where is the nature of injury?
Nature of injury is not mentioned in injury report. She was admitted because of the neck injury and she was, I think, discharged thereafter.
Learned advocate for the petitioner submits that there are long-standing disputes between the parties. The victim did not sustain any grievous injuries. The co-accused have been granted anticipatory bail by the sessions judge. Seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for bail, learned advocate for the state submits that the victim sustained injuries and had to be hospitalized. Here is the case and materials on record, although there are allegations against this petitioner of assaulting the victim on the date of incident. However, the injury report shows that the victim was discharged after 1 day. There is no noting that as to whether the injury is grievous or not. Considering the above, extend the benefits allowed. Condition: meet the investigating officer once in a fortnight until further order. Will attend the court on each and every day. We join the investigation, cooperate with the investigating officer.
33.
State 33.
My lord, I am for the state in this matter. I think they have wrongly mentioned the police station in their petition. You have written Mathabanga. Page part C, see the FIR, what is the name of the police station or the PS case number? I think you have wrongly written.
I think that they got the two appearing person. And if they don't have good faith, they're gonna take the third party.
It is not Dinata.
She
They
has,
have mentioned
it is
Dinata.
originally Dinata. What have you written? Petition. There is a mistake in the petition.
Petition he has stated Dinata police station.
Dinata. Formal letter clear. I think it is not the same PS which is written in the formal FIR.
Oh,
That is why we have a mismatch report. সিঁড়ি তো আসলে ওইটার জন্যই আসলে mismatch হওয়ার কথা।
it is Dinata 242.
Customer দরকার নেই, let it be fixed in the next circuit, we will call for this issue. And you just make the necessary corrections, you can contact the office and make corrections. Brief.
Advocate for the petitioner on the prayer learner advocate for the petitioner is this matter in the next available circuit. It will appear in the next.
So office থেকে
34. Yes. You do it. What are the allegations?
Lordship, I will beg leave to Lordship, I beg leave to appear online as a defective complainant for item number 34.
30?
34, this item, Lordship.
Oh. Then an advocate for the petitioner seeks for, was on the prayer of learned advocate for the petitioner. Next. Next available circuit. Same as 19. বুঝলেন সকালে 19 একটা অর্ডার করেছি 19 ওটাই সেম হবে নেই চলে গেছে নেক্সট তাই তো হয়ে গেছে নেক্সট সার্কিট তো শরীর খারাপ বলছে নেক্সট
Thirty-six, I am for the statement.
No, not today.
Not today, madam?
Yes. Next.
36. 37. Just
My lord,
Tomorrow.
not today.
এটা করবেন ডেটটা দেবেন আজকে নট টুডে হচ্ছে
Not.
$38 who is for the state?
I have the
CD has been received?
Yes, Mr. Secretary.
Tomorrow. Not today, কালকে Purnia police station. Any. Calcutta.
Senior, with the report this court, it is mother saying this. Also, family, next up is.
And for the state university. They are the cattle smart.
You go through the records and make your submissions. Dispose of the submission.
Family, one day.
What is this, sir? Take instruction from who is the conducting lawyer. Take instruction from move this application. CD has come.
Yes.
Yeah.
Tomorrow. February.
Not.
If I. সৈকত ছোট্ট
What are the sections? What are the sections offenses?
Section
61. See. One. In the breach of trust. And 61. Conspiracy.
Well, on the basis of statement of coercive mind and transfer, I have not said that. All the person arrested, they are granted bail by the Land Act of Man. On the basis of statement of coercive, I will cooperate with the investigation.
What did you do? Indian Telegraph Act. Your if I named accused number?
Mahendra Singh, morning. Eight.
রিপি পাচ্ছি না
7 is the last name.
আমি ফ্রেন্ড চলে আসছি
8 here. Manendra Singh. What is the allegation against him?
Police person and arrested certain person for illegal running call center. And there are from the arrested person saying that Manendra Singh is the one of the person and
I asked them about the owner.
that will be one.
এক সেকেন্ড আমরা
They were working on by Manendra Singh and Nissan Sharma since long.
তুমি এটা কোন প্রসেস ছিল
Yes. Chakraborty.
মালড কি নাম কি এটা
They used to provide fake service of internet voice call to international. Here's a teach customer making.
কোথায় মালদ দিদি কাদা কাম করছিল এটা কোন
Were hired one of the office and were trained by Manendra Singh and Nissan Sharma.
একটা ঠিক মতো
Since last
না উপরে মাথা
they were translate speech and guided by
এটা কারিম কারিম এটা কোথায় আনিসিনি ব্রিক মনে হয়
Manendra Singh. You have the Telegraph Act. You are not here.
তুই ওকে ছেড়ে দিয়ে চলে যাচ্ছিস, তুই একটু নিয়ে নিবি তো? দেখ পাশের ব্যাগে তো
Pass it over for some time. Wait.
না নট করে নট করে করে তো
5 minutes এর পাশে রাখুন সিডি পেয়ে গেলে হয়ে যাবে।
কি নাম জানো, রমেশ না?
এটা করো নট কালকে ডেট কিন্তু ওগুলো সব ডেট দিয়ে রাখবে নট টুডে বুঝছেন? Why?
Take some instruction, please.
What is the sections?
182 is there.
118 is?
Pages, 172. Just going to take some instruction into this matter.
323, 324, 326, 307, 31 IPC, corresponding section.
What is the injury?
There are case counter cases and.
What is the injury?
Injury may be grievous in nature.
Right. Okay. Leave that. Can you move the application?
But actually, the status of the counter case, I'm not aware of. Therefore, I'm praying to time.
Where it is stated in the application that there is a counter case?
Please, page 8.
What status? So there is a counter case.
The petitioner also received a head injury. There was something between both the parties. So this petitioner also received head injury. I also annexed the medical report of the petitioner also.
How many petitioners are there?
My lord is 6.
Petitioner one.
Amir. In this case,
They are in this case, one petitioner.
sole accused.
He is the principal accused, but others petitioner is there.
That's not there.
Where is that?
Out of 6, he is one of them. Present petitioner.
5 have been granted bail.
No, no. 3 accused surrender before the trial court,
Brain sizes, no obvious.
and 1 is arrested.
Normal, NCCT.
And this present petitioner along with others absconded.
Madam, I'm for the defect of order, madam. My lord, strong objection for bail, my lord, because my lord, further, you will try to attempt them, my lord. It is a heinous, my lord, head injury and my lord,
Regarding on lands, on that regard, a supplement be held between both the parties. On that, both the parties received several injuries. Then this petitioner received severe injury, which is at page, kindly take that page. 11 and 12. This petitioner has also had head injury. All the other accused persons are
Normal.
as per my
No
knowledge.
injury. 11 and 12, no injury to you. NCT of brain suggests that there is no intracranial.
11.
Let us see what is the injury and the statement.
My lord, injury report is at page 43, my lord. 43. If your lordship permit me to show the correction of head injury with a sprayed, my lord. Pending weapon has already been seized. 1 sprayed and 2 bamboo stick, approx 3 feet.
Task sheet pending, my lord?
Statement of the victim,
Yes.
Rahman.
My lord, statement of neighbor is there, my lord.
No, this victim has not been examined.
But charge sheet is pending, my lord, it is maybe.
No, no, in the meantime, has he been examined or?
No,
Not.
no, my lord.
Who is the complainant? Yeah, who is the complainant?
Rahman.
The injured.
Yes. Yes, my lord. Defective of a seriously injured. Nature of injury is grievous in nature, my lord. Weapon used, my lord, sprayed.
Case and counter case, both are similar in nature.
If your lordship kindly have a look at page 61 to 63. This is the treatment sheet, my lord.
Where are the statements of other witnesses?
My lord, at page 14 to 16, my lord. And 57 also. 14 to 16 and 57 also. My lord, 8th January 2026 fixed for IS report, my lord, that is charge sheet.
The other accused persons have granted bail.
Out of 6, 3 surrendered and they got bail, my lord. From the trial court and 2, including this present petition, are absconding. And 1 has been arrested on 23rd July 2025. So whether she granted bail or not, there is no reflection in the CD. my lord.
We have put the FIR similar receiver. So he also received several injuries.
Yes, tricky.
He has been surrendered and they got bail after statutory, over statutory period. He is the principal actor. We want 61.
Also. Then the advocate for the petitioner submits that the present case
My lord,
is counted to.
can I get
Yes.
back the CD, my lord? Just one. Just one.
Now, what do you mean? Submit that on the date of incident, there was free fight.
You know, before you
Free fight. among the family members of the complainant and the petitioner.
Yes.
Both the sides sustain injuries. The co-accused have been granted bail. There are no specific allegations against the petitioner. He seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for bail, and an advocate for the state submits that the victim sustained grievous injury in the said incident. There are specific allegations against the petitioner. He seeks for dismissal of the application for grant of anticipatory bail. Here is the case and materials on record. Upon going through the fire and the other statements, there are specific allegations against this petitioner of assaulting the victim by a sharp cutting weapon, inverted comma kodal, on the head of the victim. The injury report shows that the victim sustained scalp injury over occipital region and fracture of lower end of radius. Talk the nature of injury. Lower end of radius bracketed right hand is grievous. Rejected.
I'm grateful to you, Lordship.
দেখো তো একটা পাসও বলেছিল ওটা কি পেয়েছে পেয়েছে তো জিজ্ঞেস করো সিডিটা পেয়েছে
না, my lord, 1 day accommodation.
more than next 40
Business হয়ে গেছে।
next call
I think 43.
Yes. Lordship, praying for short pass for Ujjwal Lakshmi is court number 3.
you are there
Short pass over.
পাঁচশো করে দিয়ে এসে গেল ভালো না কালকে
44.
Sections are, the sections of the old, of the new code is 115(2), 118(1), 74, 76, 351(2), and 35. Well, it is 323, 324, 354, 354B, 506, and 34.
115 is the
Is 323 of the old code.
which one is the non-bailable offense
No, 354 and 354B, Milord. 350, which is 74 and 76.
these are non-bailable
These are non. May I know?
74 and 76 yes Give me 74 force 74 and 76 is the assault of criminal force involvement to intent to disrobe 354B 350 and 354B Both are bailable. 74 and 76 both are bailable.
Alright, that what,
So which one is non-bailable offense?
So now how anticipatory bail is,
then anticipatory bail is not valid.
I don't.
I
Why
was
you
also
have
got
filed it?
That's because the other petitioners have was granted anticipatory by the district and sessions judge.
123, let's check what are the provision 123.
123 is
Certainly,
328.
then that is not whatever not.
123 is not available.
328.
123 is not available.
Yes. Means of poison.
Now, then, Lordship, there is a question, there is a question mark, Lordship, regarding use of this section even. Lordship sees the FIR.
Now my application is well actually. Not the FIR that page 9.
Sorry, physical offense is 10 lakhs. Rupees. Gunjan and you got my body will start with the intention to kill. What are the injuries?
One of the injury.
এক মিনিট আমি দিচ্ছি এখানে and this is Lordship, the victim himself lost the complaint. It is the victim who lost the complaint. I থাকবো। ঠিক আছে? বিভাস কোথায় বিভাস? পাচ্ছিলাম না ওকে ধরো গোপালের সাথে
No admission.
No, Lordship. This is what the photographs are there, page 5. Color photographs.
Where is the order of the sessions judge granting it?
Page 17 of my application.
He also filed an application? No. He filed application.
I filed an application. I also filed an application. But page 17 is my rejection order. Page 16 is the order granting bail to the co-accused person.
No, those are bail order.
Bail order.
This is anticipatory bail order.
No, anticipatory bail. Page 16.
Oh, 16.
16 was an application for
Ah.
anticipatory.
Because the defect of government had been put in mother, he was filed with the local government was really a problem. So far as 123 is concerned, there are no allegation. 328, there is no allegation. Asun. The advocate for the petitioner submits that the petitioner has been falsely implicated in this case. The victim did not sustain any grievous injuries. The other co-accused having granted bail by the learned sessions judge. He seeks for granted anticipatory bail. He seeks for grant of anticipatory bail in favor of the petitioner. The advocate for the state opposes such prayer. Here is the case and the materials on record. Although there are allegations against the petitioner of assaulting the victim on the date of incident, however, there are no such notable injuries. Save and except swelling, bruise, and abrasions. Considering the above, I'm inclined to extend the benefit of anticipatory bail to the petitioner. Allowed.
So
Grateful, Lordship.
I meet the investigating officer. তিনটে বেজে গেছে অন্যগুলো দিয়ে দাও when is to expire no when is the interim order going to expire
Certainly, this matter was taken up lordship, but we have both
একটা কাজ করো
lordship should take only 2 minutes lordship. Your lordship can take
Matter
up.
of not moving. Tomorrow we'll see. Tomorrow on Friday.
Lordship, it will take
When
only 2
when is
minutes.
to expire?
126, lordship.
When is the interim order going to expire? এই সার্কিট করে দেবো ফ্রাইডের মধ্যে করে দেবো বুঝলে ফ্রাইডের মধ্যে
It's expired, lordship. 6
অলরেডি এক্সপায়ার্ড ওকে
in time.
কালকে করবেন কাল বা পরশু
Indicate time, lordship, because this matter of one senior advocate.
who will appear
Razik Mazumdar.
yesterday he appeared
Yes, lordship. He appeared, lordship.
you have served the copy
Yes, lordship. I have left service.
okay ঠিক কালকে নেব কালকে
126.
কালকে এক্সটেনশন গুলো ডেকে দেবে 3 pm
I think 131.
131 yes you have concluded where is it copy of those judgments you are referring to
May indicate the paragraph.
Para 10
10, 14, 15, 17, 18, 20, 20. There are actually, in this judgment, the Honorable Supreme Court has brought in all the relevant judgments wherein the concerned provisions and
the affirmation of decision clear motion that this
law is discussed.
expressed
But I would just stress on
and the increased application rating for the
Correct. 10 and 11 once.
Okay,
11
this you have placed.
This had 11 just one point.
You have placed this
In the
one
court,
and
however,
the judgment of this court, the other judgment of Justice Paul you placed on the last date.
yes, sir, I'm placing that. And before that, our High Court judgment, one more Supreme Court judgment, wherein similar fact matter decision.
Is it charge sheet has been submitted?
Actually, I am challenging the charge sheet also, because I will go to the charge sheet, because the investigation that has been conducted, my lord, no way there will be any case has been made out in that charge sheet also. In this judgment, my lord, para 15 and 16 is my lord, got it. My lord, I have read the FIR in the previous case. Here, my lord, what the court has done, if one goes through the entire FIR as a whole, it will be clear that the names of the petitioners, parents-in-law of the complainant have been mentioned in very cursory manner. No specific allegation has been made against them. Allegation contained in the FIR against them are not free from ambiguity. It suffers from vagueness so far as these petitioners are concerned. The opposite party before different authorities, this is not relevant. We're not skipping few lines. On one or two occasions, the names of petitioners were mentioned in the FIR. My lord, got it, my lord. It's 8 lines. On one or two occasions, the name of the petitioners were mentioned in the FIR, and the said mentioning of the names was in a very casual manner and without making any specific allegations against them. On my last 3 lines, only the parents of the complainant were made statements against the petitioners under section 161 of the Code of Criminal Procedure. Now, my lord, in our case also, if my lord sees the statement what the police has done, my lord, they have not taken the statement at all. They have written 4 statements under 161, which is replica of each other. Not a single line has been missed, right,
দিন
left.
কাগজ একটু।
And my lord, all the witnesses that have examined by the police
No,
are
in the FIR, there is a allegation that you insulted the complainant.
there are allegations. Vaguely, they have stated that.
Parents-in-law, they insulted the complainant.
Yes, my lord. Now,
Now, what is the evidence that is coming up in the?
there is nothing. Now, why would, before I go to that, my lord, whether even an insult would come under section 498A, that is one of the challenge I have been made. My lord, because the Honorable Supreme Court has held petty quarrels or tribal issues cannot be brought under the purview of 498A. And in this judgment, my lord, and I will be referring to a subsequent judgment also, wherein this part has been dealt with, my lord. Kindly takes para 16 of the judgment that I was placing here. In connection, it would be not out of place to mention the principles elucidated by our effects court in the case of R.P. Kapoor versus State of Punjab. The principles are hereunder, where it manifestly appears there is legal bar that is not applicable, where the allegations in the FIR or the complaint taken at their face value and accepted in their entirety do not constitute the offense alleged. And third, which I would be placing my reliance, where the allegations constitute an offense, but there is no legal evidence adduced or the evidence adduced clearly or manifestly fails to prove the charge. The third point also has to be looked into. Now, just making a mere allegation without substantiating it with any oral or evidential evidence, it cannot be termed to be under section 498. It cannot be coming under the purview. Now, considering all this decision, my lord, the FIR was quashed, wherein, my lord, Bhajanlal was also been referred. Now, my lord, my case is that they are trying to enrope me in this dispute so that they can get an advantage in the litigation. Now, after lodging of the FIR, they have initiated several other proceedings, and now they are demanding certain things so that the marital dispute now comes to an end. Now, this has become a weapon to the bargain that they are seeking. They are making an unreasonable demands from the family of the accused persons, and this is the gun they have put in the head, that there are these many litigations that are surrounding you. My lord, they have done this to wreak vengeance, my lord, and in Bhajanlal it is clearly seen. And it is the duty of the court to read between the lines. My lord, subsequent to this, my lord,
Yes, sir.
I would refer to another judgment of the Honorable Supreme Court. My lord, 498A has been disqualified because
Paragraph numbers.
21. My lord, a very short line where the Honorable Supreme Court has made a very significant observation. But the judgment facts are different, but here, my lord, para 14 is also important. My lord, kindly take 14 first. Same facts, in our case, there is no demand of dowry. So, the elements of cruelty, so far as clause A is concerned, because there are 2 clauses under section 498A, since there is no dowries allegation, only A would be relevant, my lord, I would say. A is concerned have to be classified as follows. Any willful conduct which is of such nature as is likely to drive the woman to commit suicide, or as is likely to cause grave injury, or is likely to cause danger to life, limbs, health, or their physical and mental of the woman. Now, my lord, at para 21, after considering all the decisions that has been made, cruelty was again defined. Cruelty for the purpose of section 498A IPC is to be established in the context of section 498A IPC, as it may be different from other statutory provisions. It is to be determined, inferred by considering the conduct of the man, weighing the gravity or seriousness of his acts, and to find out as to whether it is likely to drive the woman to commit suicide. It is to be established that the woman has been subjected to cruelty continuously, or at least in close proximity of lodging the FIR. Now, thereafter, that is the line I am relying. Petty quarrels cannot be termed as cruelty to attract the provisions of section 498A. This line, this has been held. Petty quarrels, my lord, in a family, there may be some misunderstanding, there may be some dispute, but to come under 498A, the gravity of that section itself says it should be enormous. It cannot be compared to those rarest of rare case principles, my lord, because here the court has to see whether it has been misused or not. Now, my lord, there is a section of causing hurt. Kindly sees the, let us take the charge sheet, my lord. With charge sheet, my lord, it will be clearly evident. My lord, I think the CD is. I had given the contents, my lord,
What
to
are
my
the
supplement.
sections? 498A and what are the other sections?
320,
506, 109 of the IPC.
My lord, now there is no injury report, my lord. Kindly state the Caesar list, my lord. Because
Yeah,
before going to the part in my supplementary affidavit, my lord, I have at page 5. Supplementary affidavit.
Yes.
My lord, kindly sees what has been seized by the police. One wedding card. Only one seizure has been made, that is the wedding card.
Because that is the backbone of marriage.
But that proves marriage, my lord, that we are not denying. But now thereafter, my lord, there are statements recorded under section 161, but none under 164. And all these statements, my lord, I would count by line, it is 20. Everyone has spoken the same thing. Replica of it. Just I am the father, I am the mother, I am the friend, I know. That is different. Rest all has been stated. Now, my lord, there are several incidents with dates.
161 statement you have given?
Yes, ma'am.
Lordship, I'll hand over the case diary. Everything is there. Best.
It would be convenient, Lordship, if the case diary is produced.
Yes. 1, 2, 3, 4 statements are there, Lordship.
Kindly note, all the 4 statements are persons known to the complainant. They are speaking the words of the complainant. The IO has not taken one independent witness in the entire evidences. That person who is residing close to the husband's house, where the alleged offense has been taken place. All the witnesses are from the house of the complainant. And they have stated that it has been told by the complainant and we are saying this. Specifically, the father's allegation, it would be seen. They have not stated the allegations wherein his presence has been stated in the complaint. He has made no statement with that regard. Because those incidents never happened. They have cleverly drafted it, my lord, and put certain names in a cursory manner.
Yes.
Thereafter, my lord kindly takes the charge sheet, the formal charge sheet that has been filed. Because it shows that the investigative agency.
Now, in this case, Lordship,
My
what
lord,
I can submit is the charge sheet has been submitted in this case. Next date is fixed for production of the production and copy supply. Charges have not been framed. At this time, at all this point can be raised at the time of charge framing.
But my lord, here, the in-laws are here before this court. Because my lord, the Honorable Supreme Court has given this duty to the bar and the court to see when such an allegation, if someone approaches the court, it should not be the duty of the court to send those persons, we are aged persons, to the protracted process of trial, wherein it can be seen that they cannot be convicted at all. There is no material in the charge sheet, my lord, and the investigation has been conducted in a very haphazard manner. No independent witnesses has been examined. No seizure has been made. But what the investigating agency has stated, my lord, that is a point that we should look into there. I'll just read the part where the investigating agency, while submitting the charge sheet, has stated, during investigation of the case, I visited the scene of crime. It's in the certified copy. I visited the scene of crime, examined available witnesses, and recorded their statements under 161, seized incriminating articles. Under proper seizure list, issued notice under this against this person and complied and cooperated in this. Now, my lord, what are those incriminating materials seized? Because in seizure list, I do not see there is any material that is incriminating to an offense under section 498A. And the statements of the witnesses that has been recorded, that has not been done of any person who is the eyewitness, who has seen such cruelty happening. Not even a closed door neighbor was examined from the husband's side to see whether these incidents are true or not. My lord, there is a principle that has been laid down by the Supreme Court in Arnesh Kumar, that whenever an FIR is brought before the police and when it concerns the matrimonial dispute, before lodging an FIR, a preliminary inquiry has to be made. But my lord, nothing has been done and mechanically a FIR was registered. And that is a very big flaw, my lord. And the persons who are suffering are before this court, my lord, because they have been falsely implicated in this case, my lord.
No, this is Shakuntala Polli is the house of the complainant.
The my lord. The complainant resides at Shukantopalli.
Shukantapalli?
My lord, I'll just confirm. It is given in the complaint. Shukantopalli.
And the matrimonial house is
Matrimonial house, my lord, that is that
Shukantapalli,
Bhaktinagar, my
Bani
lord.
apartment.
Aurobindo Society.
Aurobindo Society, which place?
Bhaktinagar.
Bhaktinagar. So this is far off place.
Different place, my lord.
Not so far, my lord.
Just it is a small town, but it is not the same place, my lord. It's not in the locality.
The nearby ward, that is on 34, what number is it 33?
কত দূর আছে? কত কিলোমিটার?
Kilometer. Maximum 2.5
kilometers, 2.5 kilometers. So
maximum.
And Deshbandhu Pada?
Deshbandhupara is just the, my lord, the borderline of the Bhaktinagar and Darjeeling and Jalpaiguri district. Deshbandhupara.
From the statements, my lord, I was gathering these locations. My lord, from the statement, it can be seen who they are related to, my lord. They have stated, I know Sukanya Chaudhary very well.
Two out of the four, two are from Bani apartment, which is also the house of the complainant.
Yeah. All are, one is the friend
The
of
other
complainant,
is Pooja Sarkar. She is
also
from
friend.
Deshbandhu Pada.
Friend of complainant.
Friend.
She stated, I know Sukanya Chaudhary very well. First
Okay.
line.
Excepting these four, there are no other witnesses.
My lord, my case, my lord, another petitioner had approached this court, my lord. And my lord, this court, after considering all the materials, my lord, held the allegations therein the FIR are vague and omnibus and such cannot
In this
lead-
case?
Yes, my lord, in this present case, one of the other petitioner.
What is the
Triphuvan
relation?
Singh.
What is
They
the
were the sister-in-law, husband of sister-in-law, and father-in-law of
Distant
sister-in-law.
relative, my lord.
Distant relative.
They have roped him. He was not there in the scene, his name has been put there.
Tribhuvan
FIR
Singh?
Yes, Tribhuvan Singh. That has been quashed by this honorable court by a judgment dated 11/4/2025.
Okay.
They were not in relation with sharing household, madam. They reside in different places.
That I'm not denying, my lord. But the section 498A should not be misused. Because that is a serious insertion in the IPC to protect a class of people, my lord. But misusing it is also something that the courts have
Okay.
taken the
So,
duty.
what is your submission with regard to the statement?
relating to
The statement, the FIR allegation and the subsequent evidence which has been collected during the course of investigation.
that has to be considered because at this moment, Lordship charge sheet was only filed. Lordship
No,
only
he
after
says
the
that
evidence
there is no
there.
allegation. He says that there is no allegation.
But Lordship in 161 statements, Lordship can find the names of the mother-in-law and the father-in-law.
No, only stating that someone tortured, will that amount to 498?
Physical torture is not there, but mental cruelty is there, Lordship.
There is no, he says that there is no injury report.
There is no injury report.
State. He is submitted. The
Lord, may I? De facto complaint. Mhm. Yes. My lord, first of all, my lord, the de facto complaint is belongs from a very poor family, my lord, and she has filed one case under section 125 CRPC that is pending before the learned trial court, and the for that case she has to hire a advocate from legal aid, my lord. She could not afford a lawyer from her side also, my lord. My lord, in this case, my lord, the section is 498A, that is the cruelty by husband and the relative. My lord, cruelty always it has to be the physical cruelty, it not necessary, my lord. In a case, Supreme Court, this Calcutta High Court has defined cruelty of mental cruelty in paragraph number 11 of this judgment, my lord. I am handing over before your lordship. My lord, the bottom portion, 11, my lord. In the instant case, my lord, may I? The learned third page.
Third page, paragraph 11, Lordship.
yes.
My lord, in the instant case, the learned court below has come to conclusion that the wife respondent of the case treated the husband petitioner with initial cruelty, as she falsely alleged that the husband, on getting the information of the pregnant, skipping these lines, but from the third line, my lord, it is well settled that one recognized conduct amounting to cruelty is making of baseless, unfounded allegation by one spouse against other. But at the same time, no hard and fast rule can be laid down as to what acts or conduct will amount to cruelty in any given case. What may amount to cruelty in one case may not amount to cruelty in another. My lord, mental cruelty is also amounting to cruelty, my lord. And my lord, if this case, my lord, be quashed, my lord, she will never get justice from the my lord, the jurisdictional court, my lord. My lord, in another case, my lord, Sundar Babu and other, the full bench of the Honorable Apex Court. My lord, another judgment I am handing over, my lord. In paragraph number 9, my lord. Paragraph number 9, my lord, the last page. Sundar Babu and others versus State of Tamil Nadu. Paragraph number 9, it has been stated that, as noted above, the power possessed by the High Court under 482 of the Code are very wide and very plenitude of the power requires grant caution in its exercise. Court must be careful to see that its decision in exercise of this power is based on sound principles. The inherent power should not be exercised on stifle and legitimate prosecution. The High Court, being the highest court of a state, should normally refrain from giving a prima facie decision in a case where the entire facts are completely incomplete and hazy. More so when the evidence has not been collected and produced before the court and issues involved, whether factual or legal.
are magnitude and cannot be seen in their true perspective without significant materials. My lord, either there are nothing that may be proved in the evidence, my lord. She may, whether she has any medical document, injury report, she can produce at the time of evidence also, my lord, before the trial court.
But then why didn't she produce it at the time of investigation? You cannot fish out evidence that, yes, I have an injury report, now additional evidence will be. Court will allow the additional evidence. Somewhere you have to draw a line that this is the investigation. You are the person who has put the ball into motion. Now you say that you have a document you can produce at the time that they will stuck there for the complainant to produce of evidence at the time when she will be examined. He or she will be examined. Can that be?
But if court allows, my lord.
No, it's not a question of allowing. If you have something, you have to produce it before the investigating officer. Now the charge sheet has been submitted. There is no application that supplementary charge sheet is to be submitted, a re-investigation has been sought for. Nothing of that sort. Now you say that in evidence you will produce that. If it is not there, it is not there. You have to admit what is in the record and thereafter decide whether this will go on or it has to be quashed. This is as simple as that. It is correct that there is a limitation in 482 cannot be exercised but the thing is, if the trial is concluded, the other aspect has to be seen whether in the facts and circumstances what is in the evidence and records. If the trial is allowed to be concluded, whether conviction can be.
Yes.
That is what he has argued. That even if it, on the face of it, what has been collected is correct. Then also what is the allegation? Primarily in the FIR, she says that the parents-in-law have insulted her. Now in 161 statement, where is the insult? Now it goes that she was assaulted and all.
Change of stance, sir.
And there is no injury report that she was assaulted.
No.
Any complaint?
No, subsequently after that.
No. Prior to lodgement of this FIR, was there any complaint lodged by her that there is a continuous torture upon her? Huh? कल के ऑर्डर से लेकर tomorrow for order.
Hello, may I be permitted to join virtually? Yeah, in the outer station. And my junior.
Produce the case that. Okay. So you can also place it tomorrow, so you can bring it here. Huh? You take it back and produce it tomorrow at the time. That one. That discharge.
Yes,
I'll get a time during the discharge. Which is the item number?
102. Today's. 102. Very urgent. We'll be landing up in. I will take 5 minutes, madam. Not more than 5 minutes. It can be taken up today, I'm ready. 5 minutes. I will not ask for single second.
The time diyo. Resolution jo na chahiye. Deepu Thapa, this one.
Yes.
CR 539.
Yes.
Motion topic তো আছে কালকে ফার্স্ট মোশন নিয়ে নাও তাহলে কালকে আইটির সময় ফর অর্ডার সেট করি নাকি আমি টাইম দিয়ে দেবো ফর অর্ডার সেটাকে সেকেন্ড হাফে প্রথম আইটেমটা মোশনে নিয়ে নেব টুমরো ফার্স্ট আইটেম ইজ ইয়োরস মোশন এইটাকে ওর সাথে রেখে দিন তো चलिए